Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Hey everyone, hello, and welcome to another weekly edition of Latest in the Law. So I have with me Uncivil Law, and Nate the lawyer is going to be joining. He said he's just running a little bit late, but I will bring Mr. Uncivil Law, Mr. Kurt, on with me. How are you? How's it going?
I am doing very well today. How are you doing today?
I'm doing well. I'm safe. So for people that have been very alarmed for my safety, I am not in Ukraine. So I'm not in Ukraine. I'm not in anywhere that seems to be in any kind of, I don't like to talk about exactly where I am, but just like for doxing reasons and whatnot, because trolls do exist. But anyhow, but I'm rest assured I'm fine. So far so good. Things are safe. If things change, I'm not going to hang out anywhere that's going to be dangerous for longer than I need to. So but yeah. So other than that, there's a lot going on in Ukraine. We're not going to, this isn't a foreign policy channel, but
it could be.
It could be.
I saw news yesterday that China was doing some sort of flybys or something in Taiwan, some sort of aggression-esque moves.
Interesting.
Yesterday. Maybe China looking to take advantage of this opportunity to perhaps do something in their domain.
I hadn't heard about that, but
it could get more exciting. It could get more exciting.
If true, that's pretty intense, pretty wild. But we have a lot of wild stuff to talk about today on the channel. Yes. Just talking about American law. So we've got the other George Floyd criminal case that just came in with a verdict today.
Did it? I don't even know the verdict yet. Ooh, I don't even know the answer yet.
Oh,
so this is a spoiler for me.
Yeah, so let's talk about it first. We can kind of talk about what you think, maybe how you think maybe this should come out, and then we can give you the result, the big reveal. And then we've got, of course, there was women's soccer made the headlines this week as well because of a massive settlement that was reached between the women's soccer team and US Soccer. And then we also have Kyle Rittenhouse. He's made an announcement, and it's, there's not too many details on this yet, but it's worth talking about because, obviously we've all had a lot of interest in his case. And he's got a new
I'm pretty black pill on all the lawsuits for Kyle Rittenhouse. So I don't know how you feel about it, but I'm like, it's like when you're saying this, I'm like, I don't really see any of these working. But when you file a complaint, maybe something will pop in my head, but
yeah, it's for me, it's going to be when complaints actually do get filed, and what those allegations are, to determine, how much of a case there really is. But I think the fact that he's been seemingly taking his time on this is an indication to me that he's at least being careful and being judicious about what he's doing. So there are some possible cases. So like he's referenced Whoopi Goldberg, how she was talking about calling him a murderer after he was acquitted.
Don't see it. What else you got? What else you got?
You don't think that one is a case?
No.
I mean, that's the one that sticks out in my mind more than any other. I think there's at least maybe enough there that there's a possibility of a settlement in that one.
I think the case law is fairly clear that calling someone a murderer, even after like an acquittal, is not defamation. Because she's like, it's ultimately, she even said, it's like my opinion that he's a murderer. It's like she's not conveying a statement of fact. Like murderer is in some sense a conclusion. And so, yeah, I think, I mean, he is technically a killer, right? I mean, he killed somebody, so he's a killer, right? So there's many problems. Like how much difference is there between killer and murderer? And, it's an opinion statement and all the rest of it. Yeah, I don't see that going anywhere.
I don't. So, but at the same time, though, you can also have, I mean, someone can't just say something and say, oh, it's an opinion. If it's more of a factual statement and they say that it's just their opinion, that doesn't get them out of defamation.
This can be true. This can be true.
So, it's again, it's gonna depend on the allegations, I think, and whatever complaint does get filed ultimately. But it seems like right now he's got a program set up, and he's got, he's fundraising for it. So it'll be interesting.
Well, we could just go more into Kyle Rittenhouse right now since we've already started talking about it, I guess.
Yeah. I mean, pretty much.
So here's sort of my back of the envelope analysis for the entire thing. Before the trial was over, I mean, from the moment the incident happened, for my money, this is a matter of public concern. I don't think that Kyle Rittenhouse was at that time a public figure, because you have to make purposeful steps to inject yourself into the public sphere to be a public figure. You have to inject yourself into public debate, public communications of some variety. You have to extol yourself into the public talking space.
Yeah.
And so prior to the end of trial, he's not a public figure because he's not. But it's a matter of public concern because, it's 2 people dead, a 3rd person injured, shots are fired in this conflagration of stuff. It's hard to think of how much more public concern it could get. So public concern is the same analysis as public figure. And of course, after the trial, public figure. First of all, it's still a matter of public concern, even though the trial is over. It's not like because the trial is over, people don't have a right to talk about it, right? So it's still a matter of public concern. And on top of that, he's definitely a public figure at this point because he's very purposefully injected himself into public debate by appearing on all the shows he's appearing on.
It's interesting to me though, because it's like, I wonder how much of that, and I think for purposes of defamation law, I think that you're correct. I agree with you, but I'm kind of just sort of stepping back and thinking about the policies behind that. And in his case, he's not like, okay, yes, he's going on media tours. That is an intentional, like, stepping forward and doing that. But in a sense, he already was there, whether or not he's going on these tours, on publicity tours, talking to people, sitting down for interviews. It's the even if he decided to try to hide out in a basement somewhere, he would still be talked about for a long time.
Yeah, but he wouldn't be a public figure for my money. It makes a difference because, again, for the same reason, like the Covington Catholic kids, right? For my money, and one of the reasons the analysis changes, at least for me, is like the Covington Catholic kids thing. They were neither public figures nor a matter of public concern.
Right.
This incident with a drummer drumming and a kid smirking, that is not a matter of public concern.
Yeah.
So one of the reasons the analysis changes from the Covington Catholic analysis is because even though they're being talked about in media a lot, that does not make them public figures under the law. What makes you a public figure under the law is you yourself have to do something to inject yourself purposefully avail yourself of the public sphere in sort of participating in the public sphere. So I don't think the Covington Catholic kids ever became public figures. I mean, maybe, way late, because there been some minor interviews, maybe way late after the fact they were public figures, but not at any time relevant to any of the things that were going on in their lawsuit.
Right.
So I think Kyle hiding in the basement would, in fact, change the public figure analysis substantially. Now, I'm not sure it would matter because, as I pointed out, this is a matter of public concern, unlike the Covington Catholic kid, which was not a matter of public concern in my judgment.
Because so, you have an actual criminal charges that were filed. That's a public hearing that is actually occurring regarding those.
Plus, people are shot. People are dead. I mean, you know, even without charges filing, that's got to be that's a matter of public concern instantly. Someone is dead. Someone has been shot. The public has a right to be concerned about that and talk about this. Geez, someone is dead. This concerns us, the public, because someone in our community is dead. Look at them. I can see the bullet hole in them as we speak, right? So I think at the moment it happens, it's a matter of public concern. You know, some guy drumming and walking toward a kid that's kind of somewhat smirking is not that. It is not look at the bullet holes. I can see them.
Yeah.
So it doesn't ultimately impact the analysis because it's a matter of public concern, but I think it's worth noting, at least in my humble legal opinion, these are two different legal things, and I think we can note the difference for whatever difference it might make.
Yeah, and I can see some people in the chat maybe getting a little maybe perturbed is the right word for it, about that it's you know, when Kyle was responding to the violence, you know, going out there, you know, trying to, you know, he was saying that he was there to defend the businesses, to defend the buildings and whatnot, to keep things from getting burned down, exactly, sort of keep the peace, basically. You know, it seems like some people would be upset about, you know, that is not necessarily an intentional act to put himself as a public name. You know, he's just being a person, right, who thinks that he's just doing a good thing. And so, you know, so that therefore, like, you know, having that kind of analysis in defamation seems unfair to a lot of people. But I think that that's kind of just sort of what happens, because the reason for the difference in standards for defamation for these kinds of things is that you have to look at it not necessarily from, well, in some instances, from the individual's intentional choice to put themselves out there. But in other instances, it's really about freedom of speech. It's about the ability to comment on these things that are happening. You know, for example, you could say the same thing of Monica Lewinsky. Arguably very private acts that she was having, you know, very private relationship that she was pursuing, but of very big public interest because it happened to be with the president of the United States, you know. And then, you know, there were issues of perjury, et cetera, that sort of developed out of there. But, you know, it's the same kind of thing. Like, you can be a private person and think that you're doing something, you know, acting as a private individual. And the moment that there's massive public interest in it,
well,
then the analysis for defamation can change.
Well, I think it just kind of turns on private versus public, which I'm just going to kind of echo what you said, but maybe rephrase it slightly. So
okay.
I'm not attempting to mansplain, but I'm going to attempt to explain the exact same concept in slightly different words. So let's see how that goes. All right. Anyway, so it's public versus private, right? So one of the things you get into that's kind of related to defamation, you can get into invasion of privacy as a concept that's somewhat related to it, right? You're exposing private facts to the world. And so this is kind of, they're related, because when you're a private person, or it's a matter of private concern, or you're talking about private individualized facts, you know, it's a private matter. And so if by talking about this private matter in the public space, you are bringing something that's private into the public space. So you are injecting this private matter by your actions into the public space. So you, the defamer, are the one that's making that choice. And by doing so, it's like, okay, we're going to hold you responsible for that additional step, right? By injecting it into the public space. So we lower the burden of proof because you made that decision. But if it's already in the public space, because they're a public figure, a matter of public concern, It's like, well, you didn't make the choice. You didn't make the choice as the defamer. It is already there. So we're not going to hold you responsible. So it's this elevated standard. So that's also part of the logic as I re-explain the same exact concept. So
no, but it's good. It's good because you did it in a slightly different way. So if somebody didn't understand the way that I put it, maybe they'll understand the way that you put it. So
I feel instantly self-conscious.
You shouldn't, because if I were a dude, you would have done the same thing.
Yes.
So same.
Well, I didn't go, well, actually.
Actually, it's this. And speaking of dudes and good dudes at that, we have with us Mr. Nate the lawyer. How are you, Nate?
Hey, what's going on, guys? How you guys doing?
We were just talking about. Kurt says he's mansplaining. We were just talking about the standards for defamation regarding Kyle Rittenhouse.
Yeah. I feel bad for the kid, but he's not winning no defamation lawsuit. It's over.
Not even against Whoopi.
Nah, not even against Whoopi. He has nothing. Have you guys seen Whoopi can use the Rachel Maddow defense, obviously. The show is literally called The View.
That's
right?
true. That's a very good point.
That helps a lot.
The View, yeah, it's my point of view, my opinion. So if Tucker Carlson, I don't know, did you guys ever read the Tucker Carlson case against the Playboy model?
The Tucker Carlson defense, Rachel Maddow defense, yes. So for anyone that's not familiar, they basically, despite the fact that they, are talking heads on MSNBC and Fox News, I'm sure you're familiar. They, and those both purport to be news agencies. Their defense in their respective defamation cases was that no reasonable person who watches their show would think that they were giving facts. They would think that they are giving, their opinion, and it's entertainment only. Basically, it's just it's no one would actually take them seriously for any factual assertions that they make, which is such a crazy thing for them to. And they won. They succeeded, which is that's even crazier to me.
Yeah. It's weird because a lot of people don't understand the nuances of defamation. It's more than just saying something that's false. It's also in the context in which you're saying it. So saying something false, for instance, like with Nicholas Sandmann, they were saying it under their news umbrella. So CNN as a news organization was saying, well, this is true as a news organization. That's different than Tucker Carlson saying it on an opinion show. Yeah. So that context matters. And First Amendment defamation law, saying it under the umbrella of an opinion show, loses any real protection for the defamation. Because it's not about what's being said at that point; it's about what a reasonable person believe it's true. And on an opinion show, most reasonable people don't believe the opinion shows are giving you truth.
And if you think about it, that also just incentivizes these big news agencies to have less factual like news programs and more editorialized kind of commentary programs, which doesn't help the public at all.
Yeah. Because now I think places like Fox News, when you watch Tucker Carlson or you watch their opinion pieces, this all says Fox News, but it's not. It's opinion. So they don't really change all the branding. They just kind of just say it's propaganda show. And the same thing for MSNBC. It's the same thing. 1 hour you're talking about hardcore news, and then the next hour you're talking about opinion shows. So it's hard for the viewer, and most viewers don't realize that Tucker Carlson's not news, but and legally they are news. So
yep. Aaron Catron, thank you so much for your super chat. And we have a question here from David Farlow, who says, does the calculus change if the reason for your public figure status is misrepresentation by national news?
No.
Well, you know what the problem is that?
Well, yes, a little bit, partially, because, okay, go ahead, Nate, and then I'll finish my thought. Either way.
Well, I was just saying, a lot of people think it's only one thing for Kyle Rittenhouse, but he has two hurdles to overcome. One, public figure, obviously, even if you're talking about limited public figure. But the second one is a matter of public concern. Yes, a murder trial is a matter of public concern, which again gives you just that same. So even if you take away the fact that he's a public figure, you still have the murder trial, you still have a matter of public concern, which still gives you the same level of protection. So it's the kid has an uphill battle Go ahead.
See, Nate is mansplaining against me because he's just repeating what I said in different words. But yeah, to your question, it matters a little bit because when you're doing defamation and the point of the analysis is the defamatory statement. So assuming that this wasn't a matter of public concern and assuming that he wasn't a public figure, the moment he becomes a public figure, he's a public figure for that moment forward. So if he becomes a public figure for the purpose of rebutting all these statements, any statements made before that point would still be analyzed under the private figure, private matter analysis, because obviously you don't go backward in time. So the calculus doesn't change for the reason you became a public figure. If you become a public figure for any reason, you're a public figure. Mm-hmm. But it would change in so much as when we're analyzing whether something is defamatory, we have to look at the time it was said, obviously, because, and also that goes for a lot of different reasons also. For example, earlier on in the Kyle Rittenhouse trial, or earlier on in the incident, the factual incident, there would be a lot more gray zone and a lot more uncertainty. So a statement like Kyle Rittenhouse crossed state lines with an AR, or even his mother helped him cross lines with an AR, right? A statement like that would not, the analysis for it would change based on exactly when it was said, because you would have to go to what you knew when you said it and what the facts were at that time. So again, it's not the same exact statement said at two different times, could be defamatory or not, because the other underlying factual picture has changed. So the whole thing, the entire analysis, including public figure status, is all time sensitive.
Well, time, I would say TPO, time, place, and manner. But even under that analysis, Kurt's wonderful analysis here, these are no doubt about it, these are opinion shows. And if Tucker Carlson, because Tucker Carlson said the Playboy Playmate had committed what was it, extortion, which is a crime, and Whoopi's saying that she believes he's a murderer. He has not. He unfortunately he has, I think, nothing. I don't think he has anything. And it's unfortunate for them to say that. Like, I know Cenk Uygur. The only thing I think, Cenk Uygur from the Young Turks is an attorney. So as an attorney, he does have the knowledge to understand the distinction between murderer and being acquitted. Maybe something like that you can get, but even with that, he's still on an opinion show giving his opinion. So it's going to be tough.
And there's also one other thing too when it comes to defamation law is that you can't get relief if it would not create a difference in the mind of the listener between the false statement and the truth, right? So if there's no difference in the listener's mind, there's no damages. So Cenk Uygur says Kyle Rittenhouse is a murderer versus Cenk Uygur says Kyle Rittenhouse is a killer, which is true because he killed somebody. So the question is, one of the questions you might reasonably ask is how much difference is there in the normal, average, ordinary person, the man of ordinary, normal prudence, the man on the bus? How much difference does it make to the man on the bus if he hears the statement, Kyle Rittenhouse is a killer versus Kyle Rittenhouse is a murderer? How much different impression does that create? So that would also be a reasonable basis to say that there's no defamation. So these are some of the many problems that face as we get through the analysis.
To be honest with you, it's a loser. Let's just, I understand people want him to win. It's a loser. He's not going to win. If he does, you're talking about changing defamation law all across the country, dramatically, unless he has something else. But
now, I mean,
speaking of dramatics. Hey, Joe.
No, Joe.
Yeah, I will point out for myself. I will at least hedge my bets slightly. Okay. Because I'll hedge my bets slightly because all this analysis is, of course, in the general, right? Mm-hmm. It's all in the general. These are like generalized principles. Like, well, let's look at time of when it was said. What did we know when they said that? Let's look at the fact he's public figure. Let's look at the fact that the difference between pleaded truth, right? These are all generalized analysis in the abstract. And I obviously completely agree in the generalized abstract, Kyle Rittenhouse doesn't have a defamation case. That being said, I leave myself enough room open that there might, in the specific, with some specific statement, there might be something somewhere. I don't know what that is.
Agreed.
I don't know what that I don't even know what that theoretically could be. But, I have not obviously done the intensive deep dive that him and his lawyers have done. So maybe they're aware of something specific that possibly could have some legs. But I'm just saying, let's go into this skeptically, and if something pops up, then we'll go from there. Hi, Joe. How are you doing?
Hey. Yeah. Hey. Okay. So my sleep schedule's out of whack.
Okay.
So I really just woke, but I'm so confused.
I appreciate you being here.
I am so confused by everything that's been happening with this channel so far in the 10 minutes I've been like conscious.
Wait, with my channel?
Yes. Yeah.
Why?
Okay. So first and foremost, no. So Alita asked me 2 days ago, do you want to come on tomorrow? But she asked me before I was awake, and then said, oh no, wait, not tomorrow. It's not tomorrow. It's gonna be the next. I was like, yes. Now I never say yes to her. I always say probably, almost definitely. Like I'm almost.
There's a strong chance.
Yeah, there's a really strong chance. And she'll always send me a link. And this time I got like no link at all. And I was like,
I sent you the link first this time.
Right. And I had no idea. So that's why, like I'm saying, that was first and foremost. And meanwhile, I'm trying to catch your conversation here. And both of you gentlemen are saying that Kyle Rittenhouse doesn't have defamation. And I'm like, what are you talking about? How does he not have defamation? That's why I say I'm so confused. Now, I actually think he has more of your law school type of defamation than actual damages. That's a very different thing. But what I'm saying is, on a law school exam, he has defamation. And it's defamation per se. I don't even know how you say that being called a murderer isn't defamatory. As far as his damages, that's a different thing. That's when you're calculating his damages, he might get nominal damages. So that's why I say on a law school test, sure, hell yeah, he checks off all the boxes that this is an untrue statement, which is harmful and derogatory without any context, meaning it's defamatory per se, and i.e., it is therefore on a law school test, this is, perfect defamation. As far as damages, well, then you can say, well, how harmful is it to him? This is a kid who's been called a murderer 4 billion times in his life. So I think it's defamatory per se. I think he wins. I think it's very possible that damages he's awarded are literally $1. Like they'll be like, you're wasting everyone's time with this, so we'll give you $1.
Joe, I'm not sure how many defamation cases that you've done in the past, and I think the problem is that you've it's like you're doing part of the analysis and forgetting about there's a second part of the analysis you also have to do. So you're right? On a law school exam, they'll say, okay, does this person have a viable defamation claim? So first thing you've done is you've gone through the elements, right? 1, 2, 3. False statement published to a third party about the plaintiff, right? That's your first 3 elements for defamation per se. But then there's a second part of the analysis that you're missing, which is now the intent. If he wasn't a public figure, then you'd have a negligence element you'd have to overcome. But now, because you have the mental element, the negligence. But since he is a public figure and this is a matter of public concern, we've all been talking about the actual malice element that he'd have to overcome. Now, there's nowhere in the United States where a public figure or something of public concern where you can go into a court and plead defamation, and if you don't plead actual malice, your case is dismissed. I can just call them right off. 1, Tucker Carlson. 2, Rachel Maddow. We can call them all off. So if you're right, I would give you probably an F, because I would say you've been part of the analysis, but you didn't complete the analysis by at least speaking to the actual malice standard. So you're right.
Well, I don't know about
respectfully, sir.
Respectfully,
sir.
Maybe.
Whoa. No. Respectfully, sir, you are flat out wrong, because you're defining actual malice as if it's as if it means get rooted in hatred, as opposed to reckless disregard for the truth. And anyone who shows any regard for the truth, anyone who's not being intentionally crazy in ignoring the truth, knows that he has been found not guilty, and that the term murderer, by definition, means that he actually has committed an act with the intent to kill unlawfully. So you're trying to nitpick and say, oh, well, there's how much of a difference is there between killer and murderer? Well, you know what? There's a legal definition, and the legal definition is murder is you're unlawfully killing someone. So even though there's an actual malice standard, and yes, I agree with you, that is part of the analysis, there is a completely reckless disregard for the truth, in that everyone knows that the statement murderer, if you look up what the term means, that he's not a murderer. So, and there is a difference between a killer and a murderer. And while in your heart, you might feel like, well, how much does that matter? That's why the damages drop from being millions of dollars to being nominal. But as far as meeting that standard of actual malice, respectfully, Professor, well, who's giving me an F, I would argue back to you.
I'm giving you an F.
Yeah, I would argue back to you. What are you talking about? That is what actual malice is, when you're showing a reckless disregard for the truth, which is what Crank Uger, which technically his actual name is Chenk, not Crank, my friend, but I think Crank is a great nickname.
I call him Crank because I like to make fun of him. But
yeah, I know everyone calls him Chunk. Everyone calls him Chunk because that's also
Chunk.
Yeah,
you know what? Yeah. The problem is, Joe, with your analysis. So I'll explain it to you. See, the problem with your analysis is that it misses some of the nuances. It's the difference between kind of just like the I read it in the book versus the actual practice. So, I would suggest, for instance, my last case was the defamation case, so I kind of had to deal with a little bit of this stuff. But regardless, if you read, I'll point you to two cases that you can read that'll explain it out to you. The first one is obviously the Tucker Carlson lawsuit. The second one is the Rachel Maddow lawsuit. They said they made claims that were factually untrue. Fox News admitted in the Tucker Carlson case that the claims they made were defamation per se, were factually untrue. They called the Playboy Playmate an extortionist. And Fox News said, that's true. We lied about her. We said it was false. But when they got to the actual malice element and the intent element, there were two things that had to come up. Number one, the context of what they were talking about it. So since you're talking about it in the context of an opinion show, the court said, well, no reasonable person, based on what we have here, would believe that what he's saying is true. And on top of that, they said the actual malice was not actually satisfied in that case too. So then myself, Viva, we all call it the Rachel Maddow defense, the Tucker Carlson defense. So if that defense is true, that is essentially is going to be the same for our boy Rittenhouse here, where even though they made these same claims on opinion shows and with the actual malice standard, there is no way that he can recover under the way the law is now. Now, if you're saying the Tucker Carlson case was decided wrongfully, if you're saying the Rachel Maddow case is decided wrongfully, where both sides admitted we said these things that were false, defamatory, instead of saying murderer, we said she's extortionist, and we know that was a lie. Unfortunately, they didn't recover. Matter of fact, they didn't even go to trial. They didn't even pass a motion to dismiss.
Dean
so
Bites.
That's what we're talking about.
What
Dean
you
Bites.
just said. What you just
Joe, we're fighting again.
What you just said though was you're blurring two different things. Mm-hmm. Actual malice, it's not a matter of a lack of actual malice. It's a matter of a defense of opinion, not a statement of fact. And that everyone would take our words as a statement of opinion, which I agree with you. Mm-hmm. Statement of opinion is a valid defense. You're trying to say, oh, well, the reason he loses is because of lack of actual malice. And what I'm saying is that's not why he loses. If anything, he loses because they can successfully defend by saying anyone who hears us reasonably interprets our statement as being a statement of opinion, not a statement of fact. And ergo, we cannot be held liable. But that's not a statement saying that they didn't have actual malice. It's a matter of saying that they weren't making a statement of fact. And that, I agree with you, could be a successful defense. But
Tucker Carlson said particularly he was making a statement of fact. They said that in his lawsuit. Those were like the verbatim words. We can pull it up right now. They said he was making, and they said Rachel Maddow made a statement of fact, and they were dismissed for actual malice. So you may be right. Maybe all the federal judges are getting it wrong. But I'll just say this. In this case, these cases are lined up. If you're telling me this case doesn't line up like Tucker Carlson, I would ask you, how is it not?
I will say there are parallels with Whoopi Goldberg in that, because she can definitely Kurt's he's going into his happy place right now.
Okay.
Hey Kurt, how's it going? So I would say that for Whoopi Goldberg, I think that she probably can use that defense, that Tucker Carlson / Rachel Maddow defense, because realistically, like, who's going to The View for factual analysis, right?
By the way, I agree.
Let's be real.
I agree that clearly a show called The View is almost by definition saying we are an opinion show. I mean, we're saying this is this is our view. That's what they're saying. They're saying this is our view. So by definition, they are an opinion show, not a fact show. So I agree with you that that's a pretty strong defense that they have, and that would make it very difficult for him to recover. I think that there's a difference between defending, I'm saying, its opinion, and which is what the Rachel Maddow defense is, and saying it's actual malice. Now, I haven't read through the text of those decisions. So if you're telling me that even though it was really defensive opinion, the federal court labeled it as a lack of actual malice, which to me is not the same thing. So in that case, I would tell you, I don't really understand the rationale of the court going down that road. They should have just said, well, they're able, it's a statement of, you will never be able to prove, we're dismissing it because you can never prove that this was a statement of fact rather than a statement of opinion, or that because we recognize, or making a finding that we recognize that most people watching these shows recognize them not as a fact place, but as an opinion place. And ergo, by definition, you can never succeed. So we're going to dismiss this as a matter of law. But I'm confused why that would become actual malice rather than defensive opinion, which I do think that there's a difference.
You may be right. It may have been puddled, but because we should just pull up the case, because it essentially it did say, though, these were factual. These were and again, I hate just not hammering it, but Fox News admitted these were statements of fact and defamatory. And it didn't survive a motion to dismiss. So, I don't know what more you would need.
Man. Well, at least Chris's error, who's been a member for 4 months, says that he'll give you a C, Joe. He says, you're welcome. Oh, sorry. He said C-. Not even a C.
I'm not worried about being judged. I feel like I defended my position at more.
Yeah. More than American. Yes.
Yeah.
Yes, no.
So.
Yeah. We're just playing around. So,
Oh yeah,
we're just joking around. Yeah, nobody's taking it seriously.
This is just fun, rigorous discussion.
Like no.
People relax. We're just joking around. Let me get caught up on some super chats here. Warren Lee says, "Missed you guys over on the Curtis Reeves watch party. Thanks for these lay explanations. You're welcome." And I know I've been meaning to get in there. I know that there are closing arguments today that have been going on this morning.
Oh, yeah.
So I haven't been paying as close attention since it started. So I don't know if things are going well for him or not. I know that the general bias, I guess, on the basic facts of the case were against the defense in this case. So probably pro prosecution, it seems like. The Dragon's Treasure says, last weekend for the contest, coupon code Legalbytes to help destroy that evil Eric Hunley. Yes. So, of course, as always, I am drinking the Dragon's Treasure tea, which is, we've got right there. It's always here we go. Dragon's Treasure. And I've got butterbeer, and I've got Iro's Legacy, if that is that there we go. Okay, so yes, they are delicious, they are wonderful. If you want to help support a small tea business and a growing YouTube channel, I don't know if I can say I'm a small YouTube channel anymore, but not as small as some others, I guess. I don't know, not as small as I used to be, but but anyway, go to thedragonstreasure.com, use the code Legalbytes for 10% off. No, Joe, we're about the same size. We're right around the same size.
A little war there going on.
I know,
subscribe to Legalbytes, unsubscribe from Joe.
Listen, matter of fact, somebody in the chat. Go ahead. Sorry.
Oh, sorry. Let me just, so if you guys are interested, there's a link in the description below. So 10% off, and you support me and the tea business. Okay, cool. That's all.
So can we move on to other topics, or no, Nate?
Yeah, no, we can. Oh no, I was gonna play the actual statement because some people were like, oh, how bad could it have been? So these are the statements that Fox News and the thing said were false.
Remember the facts of the story. These are undisputed. 2 women approached Donald Trump and threatened to ruin his career and humiliate his family if he doesn't give them money.
All this is
false. Like a classic case of extortion. Yet for whatever reason, Trump caves to it, and he directs Michael Cohen to pay the ransom.
Well, first of all, we don't know that there was actual extortion here. We know that a payment was made. There was a catch and kill deal with the National Enquirer. Whether or not it was extortion, that hasn't been proven yet, nor has it even really been alleged in many cases.
Well, I'm alleging. Let me just stop and say I'm alleging it because it's obvious. You're not going to pay $100 grand or 150 or 200 grand to someone unless there's a threat to you and your reputation. This is extortion. Now, I don't know why it's not being prosecuted. I don't know why Trump isn't defending himself on those grounds. I would, but it clearly is extortion.
Well,
so that is what it was. So that was his statements. It clearly is extortion, and the court said he cannot recover. So,
yeah.
Wow.
Moving on.
By the way, I will concur. I will just to close out. I'll concur with you. I think the analogy between Whoopi and Tucker / Rachel Maddow is very. It's a very apt analogy.
Yeah.
I concur with you on that. I happen to hate the findings in those cases, as should everyone. But
we all do. Yeah.
But that doesn't change.
Oh yeah, no. If we're going to talk about court decisions we hate and disagree with the law, man. Yeah, we could be here a while. I mean, I disagree with things all the time. The court does. It's like I did a stream yesterday where I was talking about the OSHA thing, and I didn't personally find the grounds that they struck the OSHA thing down personally persuasive. I found alternate grounds persuasive, but I'm like, well, the Supreme Court said this rationale. I'm not sure I agree with that rationale. Here's my rationale. Me and the Supreme Court have a difference of opinion, so it happens.
True. You're talking about the vax mandates?
Yeah.
Decision?
Yeah.
Oh, okay.
Yeah. This is going back a while because I was doing a story yesterday talking about OSHA trying to bring it back under formalized rulemaking. So obviously, as part of that analysis, I talked a little bit about the Supreme Court decision and I talked a little bit about the Supreme Court's rationale and be like, yeah, well, this is what the Supreme Court said. The Supreme Court said the reason OSHA can't do it, their primary rationale seemed to be the reason OSHA can't do it is because it's not an occupational risk, because the nature of COVID, in the Supreme Court's opinion, does not derive from the nature of the business. The business isn't producing the risk. It is nothing about the operation of the business that's producing the risk. So therefore, it's not an occupational risk. Personally, I didn't find that argument as persuasive as other rationales. Personally, the argument I found more persuasive was that the nature of the regulation was going outside the four corners of the business. Because unlike wearing, for example, PPE, like a hard hat, which you can take off at the end of the day when you leave the business, not so much with a vaccine. Yeah. So the nature of for me, the fact that the threat was work produced was not as much persuasive as the remedy being work related was a rationale. But maybe it's a small distinction of opinion, but nevertheless. Can we move on to the George Floyd thing? Because I don't know the answer. I don't know how it came out.
Oh,
I don't know how it came out with the George
needles,
Floyd thing.
You?
I do. I do not know how the federal case came out. I've missed this memo. I have a sneaking suspicion I'm going to disagree with the verdict. But
so this was the federal case, right?
Yes.
I don't know how it came out.
They just came out with a verdict today.
Yeah, I saw the verdict. I don't know what the answer is yet. It's a whole spoiler for me.
B movie review. Thank you so much for your super chat. So yes. So for anybody that hasn't been tracking, obviously Derek Chauvin was convicted in Minnesota on state charges last April for the death of George Floyd. It was the whole knee on the neck thing. The whole thing that sparked the BLM protests in 2020, the thing.
Thing with Joe Biden. Yes,
exactly.
Yeah.
So anyway, the other three officers that responded to the scene, they are still facing state charges, but they have been most recently in trial on the federal charges, which obviously are not televised because of the fact that it is in federal court. Much to everyone's dismay.
And we won't get those transcripts probably for a couple months, which is annoying.
Yeah, it'll probably be a long time. And even then, it's like when you read a transcript, it's different than actually seeing it.
It's not
because the same. Someone's body. There's so much that gets lost in people's body language. Their way, their tone, the way that they shift in their chair when they talk. It's so much gets lost in
the federal courts need to get over themselves with the whole. Now, I'm not so sure about the Supreme Court level, but at least for the trial level, even for the court's appeal level, I think they need to get over themselves with the video thing. Not so sure about the Supreme Court level, because at least in the Supreme Court, we have because we have equivalents, right? We have contemporaneous audio or nearly contemporaneous audio. So we don't quite run into the same problems. I'm not sure we necessarily need video. I take contemporaneous audio. I mean, it's not as good as video, but it's better than a transcript, which I'm not going to get for 3 months.
It's also
the Ninth Circuit.
Go ahead with the Ninth Circuit. Go ahead.
No, I'm just saying the Ninth Circuit's starting to do it, roll it out.
Yeah.
So hopefully
the Court of Appeals for DC Circuit is doing it.
The difference between the Supreme Court and District Court is that the Supreme Court has only one time in its history ever taken actual testimony. If it's not testimony, it's just legal debate. So tone and people pausing before answering a question versus jumping right out answering questions.
I have to give Joe a point here. I have to give Joe a point that I'm slightly impressed that you know about that one thing with the Supreme Court that they actually took testimony. So point to you, sir, for knowing that little piece of history.
It is actually
for me.
It's actually a case I was thinking, like, you know what? I'm gonna actually tell that story and basically spend an hour and a half going through that whole complex story as to how the Supreme Court once took testimony. This is going back like literally a century ago.
Yeah, it's like mid-18th, or is it early? Was it like 1820?
No, I don't think it was that long ago. It was. I think it was after the Civil War, and I think it involved. Yeah. But it involved. It's a story involving a black man who ended up being lynched after a marshal just disregarded a Supreme Court order. So they ended up taking direct testimony themselves. So, but. We'll save that story for another time. I'll probably cover that on my channel sometime when I'm bored. But because it's a really cool thing, the Supreme Court. But my point is that there's a very big difference between testimony, where someone's relaying the facts, being questioned about facts and how they respond to that, than two attorneys who are arguing about a position. Yeah, because there you don't care about their you don't really care about
their body language.
Yeah, you don't care about their body language. It's not a question of do I believe his story or her or what she's trying to convey here, or do I think she's lying? That's where you really care about that, and that's why district court level, it's really essential that we get that, so we can see, was this guy seem genuine to me or not? You get to feel what the jury was feeling. That's a really important thing. And the fact that that's not public, especially on a trial like these trials that really matter to a large swaths of the country, it's very frustrating.
That's a good point, Joe.
Yeah, absolutely. Yeah. So in this case, you had the three guys, I think two of which were rookies, actually, leading up to this. I mean,
the two guys that were touching George Floyd were the rookies. The third guy, who was a little bit more experienced, was the one with the crowd control.
Yeah.
And so,
what do you mean by touching?
Wrong?
Yeah. The person who was doing crowd control was only on the job for 2 weeks.
Okay, then I flipped it. I'm sorry.
Yeah. And the two guys who were holding the legs, one of the guy was training the other guy. And then Chauvin was training the guy who was doing crowd control.
Yeah. So for my money, and I know I'm just going to be disappointed because I kind of know what the answer is already.
I will not change my face in reaction.
Yeah. For my money. Okay. So under federal, let's just deal with the federal law elements, right? So we need to show a purposeful deprivation of civil rights. We need to show that these people purposefully deprived Floyd of his civil rights through the use of excessive force. And unless I'm mistaken in the relevant statute, and you can correct me on this immediately if I'm wrong, but doesn't it require also a discrimination element that is being done on the basis of some sort of protected class, like race? Is that also an element of the crime, or am I conflating two things?
Say one more time.
That the actual crime under federal law, to be guilty, not only do you have to deprive someone of civil rights, but it has to be because of a protected reason, such as race. Is a racial reason an element of the federal crime?
I don't think it's always. I don't think it has to be race.
Okay, well, I don't necessarily race, but it had to be some sort of protected reason, right? Like alienage or something like that. My question is
not necessarily, because you can also deprive someone's civil rights if it's like a police brutality kind of case too.
For just straight federal law reasons?
I think so.
Okay, fine. Let's go with that premise. Okay, so
because you could talk about like federal prison, for example. Like I've seen like one of the few qualified immunity cases that where they weren't given qualified immunity was where the prison guards were like literally tying up guys to like a hitching post and like leaving them outside for days.
No, I mean,
it was an Eighth Amendment issue.
I mean, you're right. I will just simply note that, qualified immunity obviously in those cases is a civil issue, and we're suing under 1983. So 1983, 42 USC 1983, of course, like every statute, has its own terms. Sure. So that you're right. Under 1983, it's just a straight deprivation of civil rights.
Right.
But under the relevant criminal law, which is like 18 USC 240 242 or something like that, 243, something like that.
Okay,
I wasn't quite sure. Anyways, moving past that issue, either way, I didn't really quite see the case for any of them for having the intent to use the excessive force and deprivation of rights. The one officer who's monitoring the crowd, obviously his knowledge is monitoring the crowd. He probably has little to no knowledge of what's going on with Chauvin and Floyd because he's too busy monitoring the crowd. I mean, the crowd is yelling things at him, but he isn't observing that. So I think his knowledge is kind of out the window. For the two people who are on him, one is obviously like first week on the job. It's like, really, this guy is gonna, just shove his other officer off the guy, just shove him off or something. And the other officers are saying things like, I can't feel a pulse. Maybe we should turn him over. Maybe we should get in this other position. So they're feeding him information and be like to their superior. And so the question to me, at least, is, I think you can get past all that if you can get to the point where you can conclude that the nature of the violation is so obvious or so pertinent that, I was following orders basically doesn't fly. Like, come on, if it were so blatant, that this officer was just blatantly, massively abusing him. But I don't know that it was blatantly obvious because, at least for my money, I'm not 100% convinced at the start with Floyd and Chauvin that it was a violation of civil rights. At the start, it was a violation. I'm not even sure at 1 minute in, it was a violation. I'm convinced by the end it became a violation. Mm-hmm. For Chauvin, where exactly that moment occurred, I couldn't quite tell you, nor do I need to, because I know it happened some point prior to the end. But then going to the other officers and their vantage point, is it quite obvious with this kind of slow boil? So for my money, I don't really see criminal liability for the other officers under federal or civil law. And this is the part where you tell me that all three officers were convicted of all the charges and found guilty, because I'm sure that's what happened.
Well, just a correction. I messed up, not you, Kurt. You were actually correct initially. I was wrong. It's actually the crowd control guy was 9 years. I don't know why I fucked it up, but I did.
Yeah, so that,
you were actually right, so I was wrong.
So that also, that massively changes the analysis.
I just thought about it. I'm like, oh shoot, I corrected the guy in the wrong way. So
it makes them all way more innocent.
Yeah, it also makes them way more innocent. Like the only other guy who would be in a position from his years of experience to be in a position to know anything, because I mean, Nate, tell me if I'm wrong, but isn't like a major theme of brand new rookies when they first come onto the job, a lot of jack shit?
Yeah,
kind of like just the
FNG,
which is also true. Absolutely zero things.
Well, we call them FNGs
about the real world. Also, kind of true of lawyers for that matter. When they come fresh into practice, is like a lot about theory, but not necessarily about the actual day-to-day practice. It's like, so jack shit. So these people who are brand new, 1 week out of probation or something, they're gonna be in a position to forcibly stop or massively question the 20-year veteran. I don't think so. Too, yeah. And then the 9-year veteran is the one doing the crowd control, so he's not in a position to observe any of these things. And he's not. I mean, what are we? He's in a conspiracy. He's an accessory. I mean, again, to be in a conspiracy requires agreement and overt action. To be an accessory requires that you have the intent to facilitate a crime, which means that a crime is occurring. If I hold the door open for the bank robber without knowing he's a bank robber, I'm not guilty of accessory. If the bank robber's tire gets a flat and I help him fix his flat, but I don't know he's a bank robber, I'm not an accessory. It requires knowledge on my part the intent to facilitate. So how is all that safe? So I am not convinced based on the evidence that's available. And maybe it's different if you hear the testimony, because none of us have heard the testimony, which is really annoying, because maybe with testimony and picture, it would change the analysis. So, but based on what I know, I'm like, I don't see it. But this again is the part where you tell me all three were convicted and are going to jail.
Well, don't tell them yet. Don't tell them.
I'm not going to tell. Yeah, I'm not going to tell you what the verdict was just yet.
I want to use my black privilege for a second. Now, why am I going to use my black privilege? The Chauvin case was not about race. Did I just say that?
I think it sounded like you said that.
I just said that. So I don't think that case would have been different if Floyd was black or white, right? I think if Floyd was white, the events would have played out the same if all the actors acted the same way. So I don't really think it was about race. And that's why even in the case, they didn't charge Floyd with they didn't charge Chauvin with any race, anything like that. So I think the federal charges about race were also nonsense. I think, unfortunately, what this case came down to was a veteran officer who, unfortunately, for him and for this victim, went too far. When you're sitting on top of somebody for the first, and I think no one will disagree, the first 3 or 4 minutes of that encounter, everything was kind of by the book. It's when the guy goes lifeless and you're still on the body for like another 5 minutes, where you're now in the reckless disregard.
I'll give you 1 to 2. I'll give you 1 to 2.
Even 1 to 2. Yes, one. I'll give you 1 to 2. But then when you're at minute 7, and then for the 2 other cops who were sitting on top of him, who one had 2 weeks experience, the other one was on for a month.
Yeah,
both of those cops asked Chauvin. Were making inquiries onto the safety of Mr. Floyd. One cop said, "Should we move him over?" Chauvin said,
Should
"No."
we put him on his side.
Yes. The other cop said, "It doesn't look like he's breathing. He's okay." So these rookies were concerned. They were asking.
They affirmatively made those statements to Chauvin, who was their superior officer, right? With a lot of experience, 19 years in the force. So this is somebody who is like, oh, okay, like if there's anyone to listen to, it's this person. And then he said, no, this is what we're doing.
Maybe we can pull the actual indictments against them, and we can see whether or not race was an element of the charge that had to be proven. Because if race is an element of the charge to be proven, then I'm going to even double down on my consternation.
This would be nonsense.
How do you convince a jury? Assuming that this is a required element, how do you get to the jury to the place of they did all that because of race when there is no facts? Because, I mean, we did listen to the entire Floyd Chauvin trial, and obviously it's slightly different factual pictures for all 3, and we have to do the analysis differently for all 3 because they're in slightly different vantage points, and even what they heard and saw is slightly different. But we didn't hear anything that would allow us to make the conclusion that those people would be in a position to what? No, did we? Joe's shaking his finger. Joe's shaking his finger at me.
Technically, you're correct that during the civil trial there was no discussion about race.
Criminal trial, you mean?
During the state trial. During the state criminal trial, there was no discussion about race. However, prior to this trial being conducted, by my recollection, Chauvin pleaded to the federal charges.
Yes.
Correct. Yeah.
Yes.
And by pleading to the federal charges, it's possible that his plea was something that became admissible into their trial as far as his admission that I haven't looked at his plea in a while. I looked at it quickly, but technically, I don't think any of us have been following this trial at all.
No, because it's impossible.
Right. But if it was admitted, I think Chauvin on the record, they would be like, well, and here as a matter of the record, Chauvin has admitted that race was a factor for
which
him.
I believe was true for his charge, if memory serves correctly. That's one of the reasons I was asking the question.
Right. So now once we're saying that race was a factor for him, if they impute that over to these other guys, which I think is possible that could have happened, even though it feels so terribly wrong to me, that and such a miscarriage of justice. So I'm not trying to justify a conviction at all. I think the conviction here is purely a mob coming after them, punishing them because it's George Floyd. Not even because it's a black man, but because it's George Floyd.
I don't think that imputation. I mean, I would imagine under the rules, unless Chauvin himself testified at the trial. Did he testify?
I think he made a statement, and his
you can't.
No, that's not gonna work.
Yeah,
Like, no, you can't do that.
Cross-examine.
No, because you'd be able to cross-examine. Like, because even assuming arguendo that he had a racial biased reason for doing those things, it does not necessarily, of course, apply to anyone else, because each person's mental state is in a different position.
I don't. You're
think
looking at it as a lawyer. You're looking as a lawyer.
I am looking at it as a lawyer. That's what I do with my time.
I understand.
That's who I am. What are you talking about?
But part of a role of a lawyer is to put yourself into where the jury is going to be, and
where the jury's idiots.
Okay, fine, but you have to recognize that as part of the whole calculus as to how things are going to end up coming out. And what I'm saying is, for them to, if they were able to see something, and I don't know if they could, but if it was admitted as a matter of record, here was his statement. If somehow that got in, which I don't think it should have, because I think it's prejudicial, I think it's inflammatory, and
it's against the Constitution.
And I think there's so many problems with it.
Violates the Constitution.
Would it be shocking if it got in? Would you be shocked if someone?
Yes,
a little bit. Yes,
I would be 100% shocked if they allowed a violation of Sixth Amendment rights in a criminal trial, his right to confront his accuser. Yes, if that statement would come in, I would be 100% totally shocked, because he's available to testify.
Let
me shocked.
Whoa, that's not Sixth Amendment.
Let me add something for clarity.
That's not Sixth Amendment. That's, if anything, it's hearsay. But
let me add something for clarity.
The right to confront your witnesses. Right. That's cross-examination.
Right.
But so let me add something for a little bit of I don't know, maybe just a different detail or context. So, for example, when you have a witness who is unavailable during trial, either because they live on the other side of the world, or because they've died before trial happens, or for some reason they are not able to come to trial, but they've done a deposition, you read their deposition into
rules.
Of course, but you can read the deposition into the transcript into trial. But generally speaking, the other side then is able to also use different parts of the transcript to basically do their side of the cross examination for it. So like even if you have some kind of a statement by any kind of a witness that comes into trial, the other side has to have some ability to respond, because otherwise it's
a confrontation clause issue.
That's just not fair.
It's textbook confrontation clause.
Right.
It's textbook confrontation clause.
I'm trying to figure out.
I would be shocked.
I'm trying. Look, I'll tell you this much. Assuming there was no testimony, assuming this is an element, which I believe we all are under the impression that it must be an element, or if
it can't be, because there's no evidence of it. Well,
that's a question.
I would be shocked. I don't believe there could be any. If they convicted him under this, it's a miscarriage of justice, because there's no evidence of it. But I'm not sure. I'm not sure.
Do you want me, or can you pull up the original indictment against the three?
Pull up
do you want me to find? Do you want
what were they convicted of?
The grand jury's indictment.
That's what I'm saying. Is I almost positive there was race.
If you can pull it up.
I'll put it in the private chat. I'll find it.
Okay.
Hold on. But then, if I start Googling, I might be spoiled as to the answer. They were all found not guilty, right?
Do you want the answer before you look up the?
Sure. Disappoint me.
Okay. Well, first let me get this super chat. Kyle Bogue says, not sure how federal jury trials select jurors, but no cop has a chance in a courthouse in Hennepin County, Minnesota. Actually, technically, for federal trials, correct me if I'm wrong, but federal trials, generally speaking, the jury pool is much bigger.
Yes.
Because I remember the in law school, we were talking about there was a Pete Rose lawsuit. There was a Pete Rose lawsuit, and I think he wanted it to be in state court, because then it would have been in Cincinnati, and so they were all Cincinnati Reds fan, right? He was on the Reds, Pete Rose, I think.
Sure.
And so anyhow, and so he wanted his fans to be on the jury, but then it ended up being in federal court, which was in, it's a much wider pool of people.
Federal districts are different. I don't know how Minnesota sets it up, if they have only one district or multiple districts, but either way, it's like you talk about the district of Minnesota, or maybe it's the Eastern District of Minnesota. But even if there's like 2 or 3, I mean, you're basically talking about 1 over X of the state. So, if it's just the District of Minnesota, then it's the jury pulls the entire state. If it's the Eastern District, it's basically half the state, and so forth and so on. So no matter how you slice it, it's a lot of people that could be in this jury pool.
Yeah.
Just FYI. So they weren't charged with any race. Crime.
Okay, good. Well,
they were charging. They were essentially charged under state authority, and so this is the failure of civil rights. So just so everybody understands, if you're a sworn officer
Can we get the statute on screen? Can you share the relevant statute?
They don't have the statute, but it's essentially, I'm reading the article. I can read the article. I can share the article though.
I don't trust the article. The article.
Yeah, I wouldn't trust the article.
But it's saying exactly what they got, what they were convicted of. Okay. But so in other words, if you're arrested.
Oh no, you ruined it, Nate.
I ruined it for Kurt. No, yeah. But if you're acting under color of state law,
all three of them were
violate my civil rights. Go ahead.
All three of them were convicted. That's what I was.
I'm dubious. I'm dubious. I am doubtful.
Have you guys the Rodney King cops? That's how they got them, because they were, even though they were innocent, they were not guilty. They still violated his civil rights because they were acting in the color of law.
But Rodney King kind of illustrates my point in some respects, because Rodney King, when you think about that incident and what was going on versus Chauvin and what's going on, and you think about what other officers could reasonably perceive in Rodney King, when they're getting him on the ground and just beating him with batons, and versus what Chauvin is, to my mind, those are pretty different factual pictures. So, I mean, I have no particular problem concluding that, the officers who are beating him and kicking him, Rodney King, on the ground and so forth and so on, that they all kind of have knowledge that this is a fairly brutal assault, that's pertinent knowledge to everyone. That seems reasonable. That knowledge imputation for Chauvin seems less reasonable. I am not convinced that a guilty verdict for all three of these officers under federal law is warranted.
Yeah.
And I take personal exception, or maybe it's professional exception, or both, I'm not sure, but either way, that we didn't get to see the trial, because I will open the possibility that maybe when the testimony is offered, and maybe when the witnesses testify, maybe the analysis would change. But since I don't have that, I just get to be a bitter crank and say I'm annoyed and say it looks like the jury made a mistake.
Here is what the prosecution had to prove. The prosecutors had to prove that the officers acted under color of law, obviously being officers or government authority, and willfully deprived someone of their constitutional rights, including the right to be free from unreasonable search and seizures or unreasonable force. This is a pretty high standard. So what they're saying is that
intentionally.
Yes, so that's what they're saying. They're saying that
purposefully,
because that they purposefully deprived Chauvin Floyd of his constitutional rights under state authority. Now Chauvin, I think he got. These other ones, I don't think so.
Chauvin, I have no particular problem with.
Yeah,
for the other officers, willfully means the same thing as intentionally, which means the same thing as purposefully, which means it was their purpose and design. It was their goal and hope. It was their desired for outcome that he would be deprived of his civil rights. That's what intent is. I desired that result. That was what I was hoping for. It was my dream that would occur. That is intent. For these other officers, with the warnings and with the one guy on crowd control and the other officers saying, maybe we should turn him over, I can't feel a pulse, and so forth and so on. You're getting to intentional in a jury. How are you getting there? How are you getting to that mens rea based on these facts? Okay. What does anyone want to offer the Steelman case the other way around? Because
sure, I'll offer it for you.
Okay, Steelman, baby, Steelman me.
For the two rookies, I can't do that. But for the officers who were there a longer time, I'm saying is that they're saying that it was that they should have known that you had unreasonable force after your 2 minutes, and then after those 2 minutes, that's 7 minutes. I think the sooner you stop, the better it is. But I think they're saying for those 9 minutes that you don't have to prove that they knew, but you have to prove that it's almost like they like any dummy would have known, right? And I think that's the way they're trying to do it.
I don't think should have known gets you there.
Not should have known, but that
you'd have to show willful blindness.
That's what I'm talking about. Willful blindness. They were willfully blind.
They purposefully, again, going to intent, they purposefully put themselves in a position to deny themselves the knowledge. So if you purposefully put yourself in that position, that's also intentional.
You can see it. You see it happening, and you don't do anything. You turn your head. You say, "Okay, I don't care." That's the willful blindness. I see it happening.
Or you think it's going to happen. Put your fingers in your ear. Go la la la. I don't see it. La la la.
That's willful blindness.
That's willful blindness, right? Yeah, that would do it.
Yeah.
So I think that maybe the argument there for convicting them is the fact that they were saying that, you know, they knew that he didn't look good and they didn't do anything about it.
They checked his
They
pulse.
knew they had their suspicions that he should have been turned on his side.
But that makes no sense though, because it's funny because checking his pulse is the thing that got them they got them convicted. We checked his pulse, so he did have a pulse. So now we're willfully blind.
Yeah, I mean, if they had not done that, that would have been willful blindness. Joe, what do you want to say? Looks like you might want to say something here.
Oh my god.
Yeah, you're miming.
Yeah,
Go ahead,
no,
Joe.
I was figuring that like speaking wasn't working, so I was trying to yell at you in sign language. To steelman it, not that I'm on the same page as you guys. This is a gross miscarriage of justice for them to be convicted. But to steelman the other side, I think that Kurt made a great analogy to slow boil, where it's like, you know, it doesn't start as a violation of civil rights, but eventually it gets there. Mm-hmm. So, you know, if Chauvin had been on him for 45 minutes, would you all say that that's not willful blindness?
Of course it's willful blindness. Yeah.
Okay. By the other three. My point is, okay, so at 30 minutes, it's also still willful blindness. So the question then is, at what point does it become willful blindness? If I turn a fire under a pot of water and I walk out of the house for 20 minutes, I know that by the time I got back there, it's boiling. Mm-hmm. So if not overflowing or whatever.
Yeah.
So if you want to steelman it, not that I think that this is a fair way to judge them, but if you want to steelman it and try and find some sort of justification, you can say that they felt that 9 minutes was too long. Would 8 minutes have been okay? I don't know. But they're saying whatever it was, that 9 minutes is too long, that you should have known he would have been dead, which is such a stupid, ridiculous perspective.
Well, that should have known.
What? No, everyone would have known. Everyone would have known.
Yeah. Because they should have known. Kurt's going to get me. Kurt's going to be like, no, that should have known. Right. So you're right. Got to be careful.
Like recklessly disregarding. It's basically saying recklessly disregarding what obviously had to have happened. Is that it's obvious he would have died. That's essentially
recklessly disregarding.
Right.
Is not intentional, willful, or purposeful.
It's
reckless.
It's what you're talking about. Willful blindness is we see it happening and we're ignoring it like it doesn't happen. So it's a higher standard. It's saying that you actually see it happening and you're okay with it. So
okay. My point being that whatever it is that they feel that you agreed that they get to if they waited 45 minutes, this jury is finding that they should have known by 9 minutes. I think it's a bizarre perspective. I think it's insane to hold these cops to that standard. I'm not surprised. I'm not surprised by it, given the fact that it's George Floyd.
I could convict you on that. You know why? Because what I would do is literally, I don't play the video. I set a timer for 8 minutes and 32 seconds, and I sit there and wait. And then let the jury just wait for 8 minutes and 32 seconds. Okay. You know how long that sounds in your quiet room? We're just waiting for. When
there's nothing else going on in front of you, that's a long wait.
That gives you your. We can do it right now, and that half the people will leave. Right? I'm saying that gives you that's very convincing. Like, damn, this is a long fucking time. So
yeah,
it gets you there. It gets if you got to get a prosecutor, it gets you there.
And my understanding is they did the same thing that they did in the Chauvin trial, which was bring in a lot of cops, a lot of experts. They had like 20 witnesses for their to put on their case in chief. So there was a lot that they introduced. So my guess is that they probably had experts testifying, saying, after 2 minutes, that was already like they would have known or something like that. He was unresponsive
Here's another factor that actually was really important. It's not steelman. This is actually a really important factor, and that is there was a crowd screaming, "He's not breathing. You need to get off him. Mm-hmm. You're killing him. You're killing him. You're killing him."
Yes.
And
he's not moving.
With them all screaming that, for the cops not to be alerted, like, hey, maybe they're not being hyperbolic. Maybe they're not being overly dramatic. Maybe they should have perhaps it could have alerted them to the fact that they were being sincere, that he was actually dying. And they were like, well, we don't care.
I mean, I wouldn't know for sure, but I'm going to take a guess. Especially for the 9-year veteran who's doing the crowd control. Probably not his first time with a crowd yelling all kinds of shit that is probably bullshit from any objective perspective, right? I mean, crowds say all kinds of crap. I would imagine you're hurting him, you're killing him. And you look, if there was a videotape there, you'd be like, nothing like even remotely close to that is happening because crowds yell all kinds of bullshit.
Yeah.
Oh,
So
yeah.
I'm not
those videos do exist too.
I'm
Yeah.
not necessarily sure the crowd to the guy who's doing the crowd control. I'm not necessarily sure the crowd yelling all those things put him in a position of knowledge, because it's like the crowd says all kinds of bullshit.
But the prosecution may have just framed it that way. That was nice for the jury to digest.
If you're looking to convict, that's part of what you're going to hang your hat on. And we know this. And by the way, here, the interesting thing about this case is, as I recall, many people on the left were furious that the jury that was selected ended up having like 11 or 12 white people. It was like, it was almost all white jury. And they were furious that they felt there was inadequate representation of in an intersectionality scale. So
these high majority white juries are just thrashing these people like Arbery, right? Everyone has to be sure about Arbery. These 11 white jurors, it's not going to be any justice. Those people are doing life without parole.
Yeah.
So these white jury thing is not working out too well for these cops, or for these wannabe cops. They're going down.
But of course, all my skepticism of the jury verdict in the world. Nevertheless, of course, I, as everyone else on this panel, is well aware when it comes to appeals, right? Yeah. We all know that innocent till proven guilty is over now. That has happened now. Innocent till proven guilty is no longer a thing now. That's over. So now, from this point forward, when you're reviewing it, all presumptions are going to flip towards the state. They flip towards the verdict.
You're talking about in these nationally known cases.
I'm talking about in every case. I'm talking about as a matter of law when you appeal. I'm talking about as a matter of law.
He's talking about after you're convicted and you appeal.
Yeah.
Okay.
Because I was like, wait, what?
Yeah, no, on appeal.
Yes, the presumption flips.
Yeah, the presumptions flip, right? The Court of Appeals is going to interpret the verdict and interpret all evidence in favor of the verdict. All ambiguity is now going to be resolved in favor of the verdict. And so the question would only be, well, there's, on appeal, you can look for, some violation, obviously, of some sort of due process violation, some sort of improperty that way. But in terms of like an evidentiary picture, the Court of Appeals you'd have to show it's against the overwhelming manifest weight of the evidence that no rational jury could possibly convict on this evidence. And so I'm like, yeah, no, this is probably not going to work on appeal. Even I, as your uncivil, putting myself in the position of theoretical appellate judge, because I'm a good appellate judge, I would probably have no choice but to affirm this verdict, despite my misgivings, because the jury heard all those things and there's nothing for me to do. Yeah. So this is the part where I, as theoretical appellate judge, start to hate my life a little bit. But then, as Scalia said, a judge who always reaches the decision they want to reach is probably not a good judge.
True.
So. But a good judge, I'm going to grit my teeth as I say, yes, the jury had enough evidence to convict. This is totally a fucking true.
But I think, Kurt, you are talking about, because if the appellate court is looking at the factual finding, trying to overturn, saying that there are no facts, that standard's extremely high.
I know.
But we're talking about the laws. I'm assuming that we're talking about, is there any legal, like for Kim Potter wouldn't be the jury. Right. It's more of a law. It's now you're based on the law. Was there abuse of discretion, which I think you do have in the Kim Potter case. I think Potter has.
Well, yeah, I mean, because you're there because you say no rational jury could convict, because as the judge pointed out several times, it's mistake.
Yeah,
and mistake kind of kills the recklessness element. Yeah. So it can't be both at the same time. So no rational jury can convict. You can get yourself there in Kim Potter, because of the judge saying the word mistake 8,000 times. I don't know how you get there in this hypothetical case. And maybe there are some other grounds to reverse, although I'm doubtful, because I'm sure the U.S. attorney, the U.S. attorney doesn't often make those kinds of mistakes. The U.S. attorney tends to be very good and tends to be very clean. Now, not to say always, I've on my own channel reviewed cases where the U.S. attorney screws up.
Oh yeah.
And sometimes the Court of Appeals forgives them anyway, incidentally. But normally that's not the thing. So my presumption going in is there's no due process problems. There's no problems with evidentiary issues. There's no problem with, things that were made at the time. Any sort of objection sustained or overturned either way would have to be abuse of discretion, because those evidentiary calls can be, it would have to be blatant on total weight of the evidence. You'd have to show that the overwhelming manifest way of the evidence, no rational juror could convict. So I, as hypothetical juror, given what I know, and just to show like how we have to put on different hats in law sometimes, right? I, as hypothetical juror in this case, am taking a look at this and I'm like, based on what I know, I don't see how I can convict. And then I turn on my Court of Appeals hat. And I say, I, as hypothetical Court of Appeals judge, don't see any way I can reverse the conviction.
Yeah.
So this is some of the things you have to do sometimes in law, and why it's important to make these distinctions important in your own mind. So, fun times.
Yeah.
And I suppose there will still be a state case. And so at that point, maybe that will be televised, and maybe we can analyze it. Maybe we can analyze that, but I'm not so sure what, if anything, I can do about this federal case, given what I know.
Yeah. I wonder if, so, and an interesting point also is that this marks another loss for Earl Grey, because he was representing Thomas Lane in this case. So, and as you know, people who were following the Potter trial will remember, he was representing Kim Potter as well. He was part of her legal team. Yeah. So I don't know if he will also be in the state case as well. But
yeah, his closing in Potter was not really great. It was like he really focused too much on the wrong thing. It's like, it was bad. I'm just gonna call it what it is. He was a great trial attorney, but when it came to closing, it was just horrible. It was just a horrible job.
I unfortunately missed his closing argument in Potter, so I don't know one way or another, but I do remember his cross-examination of the mother,
which was textbook.
Yeah, it really
but
was.
I'll probably cover these appeals on the Court of Appeals. I'll probably cover it when the briefs start getting filed and try to cover it from that perspective. But
let me know when those hit your radar, because that'll be very interesting.
Yeah.
So just to close out, there was no race, right? It wasn't race, and it wasn't, it was just them being cops and depriving somebody of their rights. So that's more or less
willfully, apparently, purposefully, intentionally. It was my goal and purpose, my desire and hope to deprive him of his civil rights. That was my hope for, desired goal, outcome in life, what I wanted to happen. I'm like, I don't know, man. I'm having a tough time with that one. Getting to willfulness. If we were on a lower standard, like recklessness, I'd be asking myself way different questions.
Yeah.
But just as a little educational brief point, there are kind of 5 different standards of mens rea. I guess we can go through them very briefly. Mens rea, by the way, is the mental state element required for a crime. So obviously you have the act, right? You do the thing.
Or actus reus.
The actus reus, right? That's the other half of the equation.
If you want the Latin version.
Yeah. And then there is kind of 5 different versions of mental state. And I can just go through those briefly.
Yeah, let's do it.
The first is negligence. It's fairly that you have a duty, you fail to observe the duty, you do so in a deficient way. And that's just standard negligence. Recklessness is willful disregard of known risks, or a risk that should have been known. Now, at this point in recklessness, you can talk about should have been known, because you are in a position where you're engaging in activity where, you would have to pay attention to that.
I disagree.
So, you don't think should have known will work for recklessness?
No, I think should have known will work for negligence. Recklessness is that you know of the risk, but you disregard the risk.
Okay.
So recklessness is I have a gun and I pointed at you and disregard the risk. And if something happens, then, but negligence is I don't know I have a gun, but I should have known I had.
Okay. Yeah. I think Nate is right on this one. I think that the correction is well warranted, and I will retract what I said in the effort to get it correct. So recklessness, yeah, you have to knowingly disregard a perceived risk. And then you act in another another word for reckless is like wanton, careless.
Yeah.
These kinds of phrases are normally used. The next step up is knowledge. I have specific knowledge of the outcome. This is slightly different than intent. It's like I know the outcome will occur, but not necessarily that I want it to occur. So there's a difference there, right? Yeah. And then of course the last step of the chain is not only did I know it would occur, I wanted that to occur. That was my hope for, outcome, desire, role in life. Yes. That was my thing, my hope for. And the last step up the hierarchy, which is very rarely used, is strict liability, where no particular mens rea is required. This is often, but not always, true in statutory rape cases where some states don't require particular mens rea. I have thoughts about that, but that's the law in some states, but not all.
There's also like for if you house some very dangerous creatures like tigers, for example.
Yes.
And they get out and they kill someone, you are strictly liable for all of those harms.
Yeah. So if you're literally playing with dynamite or tigers or something, then all your due care in the world is not sufficient.
Yeah.
And if the explosives kill people and the tigers kill people, sucks to be you. I guess you should have done more.
And also too, a lot of your traffic violations, speeding.
If you're running Jurassic Park, Jurassic Park, all the electric fences and the supplements and all the things in the world are not going to absorb you of liability when the dinosaurs start eating people. Not going to work. The dinosaurs are inherently dangerous.
Yes, they are inherently dangerous, and despite sparing no expense, even though they didn't.
Although it seemed like you spared. It seems like you might have spared some expenses. I can think of some things you might have done that might have been better.
On safety.
Maybe you could have gotten some really big titanium cages or something. I don't know.
Some bigger wires, maybe for that electric fence.
Thicker wires. Maybe
taller.
Maybe you wouldn't necessarily just rely on. Did you think about the fact that
like
electricity could fail? Did you think about that? Did you think about that possibility? So many questions. But unfortunately, they ate the lawyers. So,
did you leave enough lawyers around for them to eat instead of eating humans?
Yes, exactly.
Yeah.
Oh man.
So I am dubious on the verdict. And
by the way, I'm so resentful. I was so resentful of Jurassic Park because they didn't just take a lawyer. They basically made him a cartoonish, everything we hate about lawyers type of layman perspective of lawyers, where if you listen to his dialogue, there's not a single line he says there which is anything any competent lawyer would ever say, and he's being hired by some wealthy guy, so he's presumably supposed to be some top tier lawyer, and he is a complete buffoon. Like the first thing I think he says when he's introduced and they start talking about what Jurassic Park is and laying the foundation for the movie is he's like, his first comment is, "Wow, we're gonna make so much money from this." Like, A, no, you're not. You're his lawyer.
I will say,
and B, no lawyer has ever said anything like that in this type of circumstance. It was the most insane thing to say. But the point is, hey, audience, it's a lawyer. All he cares about is money. He's disregarding risk because all he cares about is money. So it's like they completely turned all lawyers by extension into being clownish cartoons.
Yeah, I will say though, the novel on which the movie was based, the novel by Michael Crichton, was published in 1990. So I feel like that is much more accurate for the day when that book was published as opposed to today, or even when the movie came out. Right?
Here's how you would know.
There have been quite a few reforms in the legal profession since 1990.
Here's how you would
Joe
know.
Exotic.
If he was a competent lawyer, when John Hammond came to him and said, "Hey, I want to resurrect dinosaurs and make a theme park out of it that people would go," the competent lawyer would just go, "No."
Any other lawyer today would be like, "What are you doing?
No.
Why?"
But I'm going to take safety measures.
Don't do it.
Yeah. Well, look, I'm creating Godzilla. Okay, but we have this. We have electric fence. Electric fence. Clearly, this.
What happens if the electricity fails?
And we're gonna make them all female, so we know that they can't reproduce, and like science doesn't mess up.
Right.
Yeah.
So fun times.
What else is going on in law that I can complain about?
We got U.S. soccer, baby.
U.S. soccer, but before we do that, let me hit these super chats so we're caught up. Hunch the Dirty Roofer says, Nate, please look up the case of Tony Timpa. I think
it's the George Floyd. It's the same exact thing. It's but again, we live in a woke world who don't care about facts. We're about to talk about that when it comes to U.S. soccer. So. Stay tuned.
Where facts don't matter and everything is crazy. Andy the Game Maker says, thanks for coming on my podcast, Legalbytes. Episode drops today at 3 p.m. PST on my
By the way, I've got to duck out in a half hour, just FYI.
Okay.
Yeah, me too. I got to go pick up some kids.
Yeah, no, I think we'll be wrapping this up by then. So Andy, finally, my own brother finally interviewed me for his channel after getting to pretty much everybody else in lawsuit. Maybe not everyone, but a bunch of people.
He got everyone. He got it. There was actually a guy. There was a guy who once was not even an attorney who like appeared on Nick's show one time for like 14 seconds, and I think Andy did a 2-hour interview of him also. So,
and he was like, yeah, you know, it's fine. I'll get her eventually. So we had a fun conversation. He ate a lot of bacon fat as part of a carnivore diet thing. It's a thing. But we had some really interesting discussion that we talk about interesting stuff, like, you know, generally speaking, but it was nice to have this particular occasion to do that as siblings and whatnot. So anyway, with that, U.S. women's soccer. Nate, you want to give us the update on the settlement?
Oh, yeah, they
crazy
settled.
Clown world.
Yes. So this was a fair settlement, and the women deserved it. They were being discriminated against, and they deserved every penny. Thank God for U.S. soccer. And we are all happy with it, right, guys?
So the way that you're characterizing this, let me get this straight. The settlement terms mean that the women had to give the men money, right, to equalize the pay.
No, so what? Sorry, so just so everybody understands what's going on. The women, so there was a court case maybe about a year ago that me and Uncivil Law covered, and it was great because the judge came out and said, "Guess what? All the facts and all the evidence shows that you're not being discriminated against. Matter of fact, you're actually paid more. So you have no case," and dismissed the case. And we all thought that was the end of it. The women said, "We're going to sue, even though we were paid more per game overall, even though the judge said there was no discrimination. We're going to appeal," right? So we actually covered the appeal. All of us, we actually covered aspects of the appeal. Next thing you know, U.S. Soccer then has settled with them, even though it didn't have to, even though they had already won, even though they had a federal judge say you weren't discriminating against the women. They came back and said, well, we're going to settle with the women's national team for $22 million, which is 1/3 of what they were asking for. But now that settlement has just caused a bomb in the U.S. soccer world. Number one, the older players. So just so everybody understands, this actually started with the older players like Hope Solo and those players who won the 2015 World Cup. They were the ones who actually initiated this equal pay stuff. Mm-hmm. So this settlement freezes them out. So anybody before the 2017 deal don't get any money. That means all the Hope Solos of the world. So they're on Twitter now screaming, "Oh my God, you sold us out. You didn't get us any money." And so it's only limited to the women who are playing during this period of time. The second thing is there is no settlement as of right now. It's all contingent on the men and women's team signing a new collective bargaining agreement in which the men's team has to give up millions of dollars to the women's team. They have to agree to give millions of dollars to the women's team. Mm-hmm. And if they don't, then the settlement goes up in smoke. So now they've literally put all the pressure on the men's team to come to a collective bargaining agreement in which the men would have to, again, give up millions of dollars to the women's national team, even though the women's national team is already making more money than them. So at the end of the day, this is what we got.
Oh man,
this is what we have.
Oh no, and let me interject here, because correct me if I'm wrong. Didn't the men's team like come out and with like statements saying like we support the women's team, blah blah blah. You guys are underpaid. This whole thing.
Yeah.
Oh no, they're about to eat those words.
They came out. So you know, but you can't blame U.S. soccer. So there's a couple of things going on in the background I think a lot of people don't know. Number one, there's a contentious election going on within U.S. soccer. So the current president was a former player, and then they had the past president,
former female player.
Yeah, former female player. And you had the former president. His name is Carlos Cordero. Now he was in there initially when the lawsuit started, and he made the mistake of saying the men's World Cup and the women's World Cup are two different games. Right, he's like, the men's World Cup is harder. The men's World Cup is more difficult, and the men's World Cup And the men in the women's World Cup.
Meaning there's no team competing in the men's World Cup who would lose to a bunch of high school boys.
Correct. So that's what he was saying. But that was, those facts were unkind. So so he resigned in protest. But now everybody in U.S. soccer is like, we want you to come back. So she's running U.S. soccer. So politically she's saying, hey, the election is next month. So politically she's saying, well, hey, since we got an election next month, I can settle with the women. So she did this settlement, which actually doesn't, they haven't paying anything. So they made this settlement. The second thing is it allows both U.S. soccer and the women's national team to blame the men if this deal doesn't happen. So they can just say, hey, the men's team is not the one.
Blaming the men? Blaming the men? Surely that would never happen.
For being selfish and not giving up the millions of dollars.
The women's team, women blaming the men? I mean, I don't see that happening, Nate.
But that's what this gives them. That's what this gives them. And don't forget, everybody's been saying this is equal pay. This is so great. But under that contingency deal, it's really, really bad. And then last, they actually offered both teams the same deal. And the men's team has already rejected the deal because they said the men's team actually threatened to strike before, but they rejected the deal and said, well, hey, we can't take this deal because you can't. And just so everybody understands, the Men's World Cup has a $6 billion revenue stream. The Women's World Cup has a $300 million revenue stream. But the women
billion versus 3 million.
300 million. 300 million.
Sorry, 300 million.
It's 1/20th. That's 1/20th the size.
Yeah.
Yes. Yeah. But the women want to be paid as if they won the $6 billion tournament. And that's the problem that you come into. So the men are like, well, hey, we're playing against Ronaldo and Messi and we're playing for a $6 billion prize pool. Why should we give that up if we win to women who, and one of the biggest issues too is that it's so bad that if the men just make it to the World Cup throughout the first round, let's say they make it to the second round, they make double what the women get if they win the World Cup. So, what's going to happen? Are the men going to, if you were the men, would you give up this? But now you got all this public pressure. You got all the news media, everybody saying this is great for women, great for women. Only thing the men got to do is say yes.
Oh, boy.
Would you say yes? I wouldn't say yes. I'd be like, no, F this. We're going, it's not happening. But
read between the lines.
That's where you're at.
Yeah.
I mean, especially after these guys were not paid throughout the pandemic because there were no games, right? Because they're on a strictly pay to play program, right? So if they don't play any games, they don't get paid. And if there are no games because there's been a pandemic for 2 years,
yes,
then they don't get paid at all. Now, of course, a lot of these guys are getting paid elsewhere for being on other teams, right? I think that's one of the reasons why.
Be that as it may.
But still, like these guys are not getting paid anything over the last 2 years for being on this team and having this contract with them. And now they're supposed to give money after they haven't been paid for 2 years. That's tough. It's really tough.
The sad part about it is that, like everybody, like you see a lot of people on Twitter, what they'll make the men are getting paid through their clubs. But that's just like me having two jobs. I'm working at McDonald's and get paid, and then they'll say, we want you to give half your salary to Jane because you're getting paid from Burger King too. You're like, no, what do you mean? I work at Burger King, right? What the hell does Burger King have to do with McDonald's, right? Why I gotta give half my salary at McDonald's because I work at Burger King? No. I'll quit the Burger King job. I'll quit. It's like no. So it's just ridiculous overall. But don't get me wrong. For the women's team, let's be honest here. This was fantastic, right? If you can get $22 million,
they squeezed some blood out of that stone,
wasn't it?
It's we had 22 in back pay and $2 million, and and pet projects that they want to do.
Yeah.
Okay.
So that was a dried up apricot that they were able to get some juice out of.
because basically they said we're going to punish this guy for making a true statement that men's soccer and women's soccer are different, and they basically said they went woke and now they're going broke.
No, they didn't go broke. They went. Yeah, the women's team.
They said, "Oh, sure, let's get rid of this guy. Let's pressure him out. Let's be woke and pretend that what he said isn't obviously true, and punish him. And now, because they decided to punish him, that's why now they're going broke."
But he's back though. But he's back because the U.S. soccer people, everybody was begging for him to come back. So he's back and he's running for president. The election's next month. So now that's why everybody. So because everybody kept saying this is kind of just rushed. So that's why this was rushed, because she wants to continue to be president. But he's running against her. So now she's, this gives you a lot of political capital. Look, I shut Megan Rapinoe up. That you should hire me just for that. And on top of that, think about it.
You can shut Megan Rapinoe up. That's not half bad.
But also think about this. She hasn't even paid anything yet, right? I honestly think the U.S. soccer woman did a wonderful job, because she did two things. She shut the women up, right? All this great well, and put it all on the men. And now when she goes into the election, she's like, hey, it's not my fault, right? I just, I did everything I needed to do. I broke the deal, and it's the men. It's the men. These idiot men again.
Those greedy men who want, $4 million out of the $9 million they'd win for the World Cup, but the entire World Cup winnings for the women is $4 million. So,
it also depends, though, on who it is that's going to be electing this position, right? Who's actually voting for?
It's the board of directors for U.S. Soccer. They're not for profit, so the members of U.S. Soccer.
Okay.
How do you broker a deal? And when we covered this before, and I think it was Nate and me on Nate's channel, it's like the 10th or 11th or 12th paragraph in the finally getting around to it in the New York Times, where it basically says, yes, this is all contingent basically on a unified CBA. We have to unify the prize pools, and I've been saying forever, this is the only way to make it work, because there's just literally not the money. It doesn't exist. The entire amount USA Soccer would get for the women's winning the World Cup is $4 million. The entire amount that they get for the men winning the World Cup is $9 million. It's like, I can't pay you out of the $9 million, women, because it just doesn't exist. It's a fantasy.
You're just picking it out of thin air.
Kurt, it's worse than what you would for winning the World Cup. The women get $4 million, but for U.S. Soccer gets $4 million, which the women get 50% of that too. For winning the World Cup as a man, you get $38 million, and the men's team gets paid $9 million in bonuses. So it's even crazier than that. Right. So you're about $4 million versus $39 million.
Yeah.
So, but now the women, just think about this. The women are saying, well, if we win our World Cup, we want the $9 million. You're like, but hold on, even your whole tournament doesn't pay out $9 million. What the hell? We're sitting your tournament making
$4
million.
Yeah, we want you to give us $9 million out of the $4 million.
You're like, what? No. Well, if the men are stupid enough to give up their money, then yeah. Which the men's team isn't winning the World Cup anytime soon. But
I don't know. I'm an optimist. Go USA.
Women. You're not rooting for the women's team anymore, huh? Women's team is done for you in your mind.
I'll root for them if they're in the World Cup. Hell yeah! I mean, it's representing the United States. It's representing the United States.
I did. No one's rooting for them anymore.
Now, Legalbytes, as our resident female, I will ask you the same question I asked Nate when I was on the stream with him, because I'm going to paraphrase this slightly.
Okay.
But because they took note of the fact that USA Soccer, in one of its earlier briefs that was ultimately withdrawn, said that the men's game was that there was more responsibility, and what was the other word that they used? It was more
the men were more
competitive.
Yeah, more competitive,
more skilled, or more competitive, something like that.
Yeah,
either one. And then Megan Rapinoe has this quote about how that is just plain misogyny. So I asked the question to you, Legalbytes: is it misogynistic for me to note that the level of competition and the level of skill is different in the Women's World Cup versus the Men's World Cup? Is that a misogynistic thing for me to take note that women may not be able to necessarily perform the same physically or at the same level of skill as the men?
So I think it depends on how that statement is made, because if you were to say, for example, put Megan Rapinoe, put these women up against Ronaldo or Messi or some of these guys, put them up against them and see how they perform, I think that would be factually accurate to say they would not be up to that standard. I think wasn't it Venus or Serena Williams or something that famously made a statement like that?
Said that men's and world soccer were the same on David Letterman. And then of course, what was it? The guy who got into so much trouble for saying that Venus Williams would be ranked 700th, McEnroe, who said that.
Yeah.
And it's like, would you withdraw that statement? It's like, no, because that's about right.
Because if you were to actually pit them up against these other players that are male, and that's, I mean, we don't need to go down the whole rabbit hole of trans athletes, but that's really where a lot of that comes in. That whole conflict of whether or not to allow trans women to compete against biological women.
Yeah. This isn't, of course, to say that all women are weaker in sports or athletics than all men. For example, our very own Legalbytes can run, and yours on civil law cannot. So if we were in a running race, Legalbytes would kick my ass.
Yeah, I just ran over 5 miles today.
I can't do those things, Legalbytes. So if that's the competition, Legalbytes is going to kick my ass. Also, if it's me versus Megan Rapinoe, Megan Rapinoe probably kicks my ass.
Yeah, and very long distance running. Actually, there are quite a few females that have been in like ultra marathoning that actually have been shown to be very, very, very good in when actually running against men. But anyway, that's also kind of a different situation.
Also, long distance swimming too.
Yeah, I think so. Yes. Swimming, yes. So, but if you were to say, women against, women in the women's league versus men in the men's league, I think that's much more of a matter of personal opinion about whether or not you see the competition between those women as being, worthy of your attention and entertainment value, like that kind of a thing. That's much more of a personal opinion rather than to say, okay, if you were to line up these individual female athletes and have them play against these individual male athletes, then, then who would win? Like we could all probably predict.
I didn't suggest that they weren't worthy of attention, and I'm not even suggesting that, given the premise that the skill levels are different, that you shouldn't enjoy women's soccer. If you enjoy women's soccer or anything else, then go nuts. I can take note of the objective realities that these sports are just not equally popular, which also is driving the finances.
Yes.
Yeah,
that's just reality.
I would, and that's something that you can track with data, right? That's not a personal opinion. That is something that you can actually track with data, that how many people are watching these games, how many people are buying tickets to these games, so, and that's what drives how much money they make.
And I do want to make the point too, is that the women's league is the discriminatory one and the men's league is the one that's not discriminatory, in the sense of there's no bar to gender for women playing in the men's World Cup, right? It's not like you have to be a woman, right? There's a bar to playing in the Women's World Cup. No man can play in the Women's World Cup, just like with the NBA. People think that the NBA is discriminatory, but the NBA, if a woman can play in the NBA, she'd be able to play. That's why they don't call it the men's NBA. They just call it the NBA, and the women NBA is the one that's discriminatory against gender.
I was just going to say, I was actually going to accuse the men's soccer league of being misogynistic and that they don't allow women to come play in the men's soccer league. Why don't they allow any women?
They do. You can.
They can go play. How many make it on there? How many make it?
Well, that's a whole different story. But there's another like, for instance, for football in the NCAA, like women, we just had a woman who played in the Division I football, who she kicks field goals. But that, again, a lot of people have this notion that there's a bar to even get into, that women can't play in the men's league, but that's just not true. If they are skilled enough, they can play.
And that's really precisely the point that's undercutting all of this, is the very best female soccer player in the world is worse than the very worst male professional soccer player.
It's probably true.
I don't know.
That's why they're not there. Otherwise, they would be there.
I hate you and your damn logic, Joe, but I don't know, man.
Good logic.
Yeah, good logic. He shut me up.
At least on
logic
the
shut me
men's
up.
Team.
Damn.
At least on the men's USA team. That's true. Yeah, the very best is not as good as the very worst. Otherwise, they'd be in place of the very worst. Yeah, can't fight that logic.
I mean,
all right. Well, okay.
Yeah.
Joe shut me up.
Probably right.
That was good, Joe. Joe made me fucking swallow my words. Hey, but play this video. This is John McEnroe when they tried to cancel him about the Serena Williams thing. This is hilarious. They were trying to cancel him, but he came. But you know what though? He came out as a grown man.
Right. Why was
no
it
pun intended
necessary for you to say that anybody, Serena, couldn't beat the 700th player on the men's circuit?
As you know well enough, Charlie, I've respect Serena very much so, okay? And I was simply calling her on an NPR, which supposedly you're supposed, this is where you can say it like it is and you're going to get honest feedback. She's the greatest female player that ever lived. Then the lady said to me, I don't remember which one, but she said, why did you say woman? Why don't you just say the greatest, tennis player that ever lived? And so then I felt the need, however, unfortunately, I'm probably to defend myself. I don't know, just say what I really felt. I mean, which is about what I think she would be. I think you're referring to the fact that I said she'd be about 700 in the world.
Yeah.
Right.
I've got a solution, Gail, though, because I know that you're friendly with Serena, and I think at least until yesterday.
I'm right now. I'm just waiting. Would you like to apologize?
No. But the offer is this, is because it seems in tennis, unlike other sports, that they're always asking about how women, they always ask me how I would do for someone. Why isn't this old bag John McEnroe, how would he do against Serena? Why don't you combine, just solve the problem? I'm sure the men would be all for this. The men and women play together. And then we don't have to guess.
But John, you didn't answer Charlie's question. You really should. You really do need to answer Charlie's question.
What was it? I didn't. You're right. I wasn't paying attention.
Necessary to do this.
Yes.
It wasn't necessary. It was not necessary.
You knew it would create.
I didn't know. I didn't know it would create.
You didn't?
No.
John.
Has anybody ever?
I've said this 1,000.
Does Bobby Riggs mean
Charlie,
anything to you?
What do you think, Charlie? You're a tennis guy. You like to play tennis. I see you on the tennis court.
Right.
What do you think that Serena Williams would be ranked if she played in the men's game?
I have no idea.
Well,
You don't?
If you had
You have
a
no
guess.
idea?
She seemed pretty strong to me. I mean,
Very strong. The
but
greatest female player ever.
No idea.
I can prove this. Here's what she said. Dear John,
They're the greatest women play ever.
I adore and respect you, but please keep me out of your statements if they are not factually based. Or that
pretty
or not.
factually based.
They're not factually based.
Serena's, has a
Why
way
did they
with
highlight
words.
that part about her trying to have a
I've been
baby?
in the room 5 different times with 5 of my kids were born. I don't want anything to go wrong with Serena because she's pregnant. I don't want to upset her or whatever it was. I think she was doing it tongue in cheek as well. And I think that deep down, we're talking about something. I can't even believe we're talking about it. But
John.
nonetheless, if you want to keep talking about it, I'd be more than happy to.
I do. I actually do, because I think everybody knows.
And another thing.
No, men are stronger. Men are faster. We all get that. But I think it sort of belittles what women do on the tennis court. I think that's why people are upset. And the fact that you ranked her at 700. So my question to you is, she won Australia weeks pregnant. You ranked her at 700 on the men's. Where would you rank yourself?
Myself would
where
be.
would you put yourself?
Now, are you asking me at 58 years of age, would I be ranked in the tour if I had to play best of 5?
Yeah.
Which is what the men have to do at majors?
Yes.
I would be currently about 1,200 in the world.
I mean,
I'm just.
Cricket.
Shut them up.
I'm not better than her. At 58, I'm not
high
better
school
than her.
kids, and I would lose. There's pros.
He said, "I lose the high school
37
kids."
pros now in my club, 6 or 7 of whom on a bad day I would lose to.
Okay.
And we could go on and on. I was the former number 1 player in the
John,
world.
what do you say to this? People just say, look, John McEnroe's trying
I
to
was
get
number 1.
publicity
Now I'm
for
number
his book.
1,200.
That's all.
Well,
I
am.
He secretly wants to
but not this
play
way.
Serena. He secretly.
I never wanted to play Serena. People always ask me about playing Serena. Did they ask Roger Federer about playing?
Okay, so let me.
So that's more or less it.
Yeah. Keep me on things that aren't factually based, but it is factually based.
Well, I mean, the fact that he's like, well, I would be 1,200. He's talking about objective things, strength, age, mobility, those kinds of stamina, those kinds of things that are very they're tied to physical ability, right?
On a bad day, he says, on a bad day, I lose to club players.
They just
five or
dislike
5 or 6 club players who can beat me when I'm on a bad day. So I'm about 1,200 in the world at this point. Yeah, I was number 1 because time is a bitch.
It seems like they just dislike him giving his very brutally honest opinion.
And I love that question back to them. It's like, okay, you play tennis. Where do you think I have no idea. I'm like, really? You have no idea. Would you like to maybe take just a range, maybe a range? Do you think she's number 1 among all tennis players? Do you think she's number 500? What do you? Where do you want to put the number? And we're trying to determine, a factual reality. And then I love his counter suggestion of well, if people are upset with me guessing, we could just find out. Let's actually just run it. Let's just run the reality, and they'll all play together, and then we'll know for sure.
Yeah.
And even if McEnroe is off by 200 places, even if she's 500th or if she's like 400th in the world, even if that's true, I mean, his overriding point is still true. I mean,
well, you know what, and you know one thing about that, they deceptively didn't put what Serena actually said. So this is what Serena actually said when it came to it, and they were trying to be deceptive about it. But this is what she said about playing men.
Well, who would it be?
Well, I don't know. Let's say you would be the.
I was hoping you'd say.
All right, feminine side.
And this is her on Letterman for anybody that's listening instead of watching.
Well, actually, it's funny because Andy Murray, he was been joking about myself and him playing a match, and I'm like, Andy, seriously, like, are you kidding me? Because for me, tennis and men's tennis and women's tennis are completely almost two separate sports. So I'm like, if I were to play Andy Murray, I would lose 6-0, 6-0 in 5 to 6 minutes, maybe 10 minutes, because it's true. It's true. It's a completely different sport. The men are a lot faster, and they serve harder, they hit hard. It's just a different game, and I love to play women's tennis. And I only want to play girls because I don't want to be embarrassed. I would not do the tour. I wouldn't do Billie Jean any justice. So Andy, stop it.
Yeah,
I'm not gonna let you kill me.
I'm with you when it comes to tennis. I only want to play girls.
Yeah.
But she's being realistic there. Like, I can't play on the men's team. That's ridiculous. But they wouldn't play that clip, though. They wouldn't say that, right?
6-0, 6-7, maybe 5 to 10 minutes, man.
It's a totally different game. What are you guys talking about?
Yeah. I mean, and that's the thing, is that when you're actually a player in the game,
yes.
I mean, you know what the realities are. Because you're the one that is training every day. You're measuring yourself up against your next competitors, keeping track of everybody else that's on your field of competitors. And so it's like, of course, she's going to have a very realistic view of who actually her competitors are.
Yeah,
how much
people asking him to apologize. I feel like anyone who asks him to apologize should answer the question of like, okay, if that's wrong, what is the right answer? It's like, okay, you want me to apologize for what I said? Fine. What is the right thing?
Yeah.
And it's like, what is the right number? And no one is willing to answer that question, because any realistic assessment, I mean, even if he's overly cautious or overly critical, it's not off by like an order of magnitude. It's not like it's 70 versus 700.
Yeah.
So it's not that wrong.
Yeah.
But one thing I do want to make the point for the podcast too is the fact that in women's tennis, women actually make more than men, right? And and why is that? It's also because there's an element of entertainment. People wanted to see women play tennis more than men play tennis, right? So even in that sport, even though it's the men's game, we would all consider to be more difficult, but that the economics are different because more people want to see the women play. It's just a fact.
I'd much rather watch a game of women's volleyball than men's volleyball.
So it's agreed. But it's funny because when you bring that
to do with the uniforms.
It has nothing to do with the uniforms. Pure love of the game.
But it's okay to say that, right? It's okay to say that, even though we can admit that a man would win all the women's tournament all the time. But in this case, where it's the exact reverse, nobody has a problem with that. Even though the men play 5 sets and the women only play 3 sets and all these other things. But then when the opposite is true, now everybody has a problem with that. It calls it equal pay, and nobody's claiming the men should get equal pay in tennis, right? Nobody's saying the men should get equal pay, right? Yeah. That's because we all recognize. Obviously, it's economics. If people want to go see them play, they're going to pay for it, and that's why they get paid more.
Yeah, agreed. Let me get a few super chats here. Hunch the Dirty Roofer says, since the majority of those eaten in Jurassic Park 1 were employees, wouldn't this be a labor law dispute? And could there be an assumption of risk in contracts? I mean, that would be assuming that they even had an employment contract to begin with.
I think as a matter of at least U.S. law, that all the assumption of risk in the world in this contract is not going to save Jurassic Park. Because if you come to me with this and be like, they agreed, assumption of risk, look where they disclaimed this, I'm going to be like, unconscionable.
Well, hold on.
Void,
hold on.
Not happening.
I gotta say, I'm not really too sure if you guys ever deal with workers' compensation law, but generally, if you're hurting a job, you can't sue your employer for, it has to go under the workers' compensation.
That's true, and it's a much more limited scope of damages that you can get.
So if you sign up for Jurassic Park and get eaten, it's like, workers' compensation board.
I don't know much
Jurassic
about work
Park
comp
was
law, but I have to tell you, man, this might be the exception that proves the rule. Because if you're like they're limited under workers' comp law, I'm like, I don't know, man.
A dinosaur ate my arm.
It could also depend. It could also depend on the circumstances, by which they found that job. Was this really like a real offer for work, or did they fully understand the scope of the responsibilities when they were accepting that job? Also, it took place technically in Costa Rica, so I don't know Costa Rica.
Breaking news! Biden Supreme Court nominee.
Johnson or Jackson?
Brown. Yeah, Brown Jackson. Yes.
Yeah, Jackson. What is she? Court of Appeals for DC?
They're attacking her. The Republicans attacking her as radical left pawn.
Is Jackson the one that's on the Court of Appeals for DC, or is she the one that's Supreme Court of California?
Looking at it, it says she's from. It doesn't say. Reading it, South Carolina.
Ooh, really?
She's from the Court of Appeals, District of Columbia. 8 months ago, she was just
District
elevated.
of Columbia. Okay,
yeah,
so
DC.
that is the okay. So yeah, this is the one that was just elevated to District of Columbia. She's, I think, rendered one decision so far as she just came up with her first decision as the Court of Appeals judge, but obviously she had like 8 years.
Yes, she's radical left.
Before that, she is compared to some of the other choices. So it is not surprising it's Jackson.
Yeah.
Because among the picks for Black women, and there were, and as who was it? The CNN contributor noted, there would be other choices that might be more left. Like there's that Indian American guy whose name temporarily escapes me, who might be even more leftist pick. But among the Black women pick, she is probably the furthest left of the picks that were possible.
Oh, she's getting on. She's getting on.
I think the odds are high for her to get on. I think it's likely all the Democrats will vote for her. I think it's likely that, of course, Kamala Harris would break any tie. So I think the odds of her getting on have to be favorable.
Yeah,
but I will say this though, and I know I took a lot of crap for this on Twitter. Is that I would have rather him just say, "I'm going to nominate the best person," and this was the best person, and this was the person he put up. I think this whole going out and saying, "I want a Black woman," I understand why he did it.
Yeah,
but it does taint it a little bit to say, well, I'm only going to narrow it to only this, based on
which is a little bit unfair because
it's unfair to this woman, yes, because she's qualified.
Yeah, it is unfair because in the scope, if you're Biden and you're looking to find someone who will support, leftist agendas, then even in the scope of all possible nominees, she's definitely in the running. Yeah. It's not like she isn't in the running. In the scope of all possible nominees, she'd be a rational choice for that position. There's that Indian American guy who might be a better choice, but she's still, she's probably top 5, if not higher, in the scope of all possible nominees. So even in the scope of all possible nominees, you wouldn't be surprised to see her name. So it is a bit unfair to her.
I think
because it introduces this cloud above her, like where people will ask, there will be those that will ask, why was she
known? Yeah,
as the affirmative action pick.
Exactly.
And it's interesting because some people said George Bush did it with Clarence Thomas, but I don't remember him saying he was going to nominate. No, he did say he was going to nominate the Black person to the Supreme Court.
Oh, do you guys want to see Biden's remarks? They're about to start.
Oh, sure.
I guess we could. I don't know if you guys are. Hang on.
By sure, he meant I'm out of here. Was that? What he meant?
Oh, I guess.
He's like, all right, I guess we're done here. I'll go watch them on my own. I guess he didn't think he meant with us. I don't know.
Okay.
That was kind of funny.
Let's see. Oh, he's back.
Okay.
Yeah, my browser.
I'm going to have to bail for now because I promised someone else I'd do something at 1:00.
Oh,
but if you guys are still on when I come back, then we'll talk more. But the nominee doesn't surprise me. She is an obvious leftist pick. She will be a reliable leftist vote for years to come. And I do look forward to her asking questions rather than Breyer. So I got that going on. So that's nice. But I got to bail.
Okay.
Later, brother.
All right.
Might be back.
Later.
All right. See you, Kurt. Well, actually, in that case, let me get these last couple super chats at least, and then we'll close out instead. Andy the Game Maker says, Grandpa Joe, my guests are part of a process to see if I can actually find someone who agrees with your position regarding the theory of relativity.
Good luck.
Yeah, you got to give Joe credit today. Joe shut me up. He had me mumbling over for a couple of seconds. So
yeah, I better appear on legal on the whole
on the clip show
thing. Yeah, that doesn't make the clip show.
I will try to make a note of it.
I hate you, Joe. I hate you.
Grimm's Bar wants to know, unrelated, did you all see the "If I Was Your Mother" Putin video? That was by I did see that. It was some kind of a poem. I don't want to talk too much about Ukraine, but
I covered it on my stream last night. Yeah.
Oh, you did?
Yeah. I did a detailed deep dive into her so sincere. If I was your mother, I would have shown you love.
Yeah.
Oh my gosh.
I think that Putin's reasons for I don't know. Well, I don't know. I probably shouldn't go into it, but it probably had a lot more to do. His reasons for invading Ukraine are probably beyond the scope of just like my mom didn't love me. So this whole idea that like she could have prevented it somehow is a little bit too self-congratulatory.
Self-involved, a little self-involved. Yeah, that's why I actually named my stream last. It was in homage to her that I named my stream last night. Thanos was right.
No.
But you know, though, I gotta say though, I understand why he did it, but you know, I just wish there was another president there who would have challenged it, right? Because it's kind of he did this with Obama when he took part of Crimea, and Obama was, it's like the Democrats. He knows the Democrats are scared to push any button, so and that's why he didn't. That's why I don't think he pulled the shit on the Trump, because I think Trump, would have put foot in ass. But it is what it is.
I've been really burying myself into this whole thing, and it's really way too long for us to start on it.
Yeah, it's a complicated issue.
Yeah, but I will tell you that my perspective as of today, February 25th, today's 25th, February 25th, is that this entire thing is a money fight between Russia and the U.S. This is a money fight between over the pipeline. This is all a money, and that Ukraine is a pawn that they're both fighting over. That's really what it boils down to.
The Europeans and Ukraine,
and it's really just a pawn, and it's a shame, because honestly, I think Zelensky. Look, there are a lot of problems that are going on in the Ukraine on both sides, but I'll tell you this much: I don't think that Russia is innocent. I think that Putin is pretty bad guy, and I also think that USA has done a lot over the last 30 years to try and create this situation where they're going to have a monopoly on the energy, on supplying energy to the EU. And that's basically, and this whole thing, the only interest we have in the Ukraine is that we want to maintain a monopoly on providing energy to EU and keep Russia out from competing with us. And that's kind of an insane reason for us to be involved here, because they're not a member of NATO. We're not supposed to be. We should have just said nothing. And that's what should have happened. We should have just been like, this is not our fight.
Well, don't forget, the reason why we're in there, because he wanted the declaration that Ukraine would not join NATO.
Yep.
And we can and for people who don't know, they've been talking about this for 50 years, from the Warsaw Pact to NATO, and it was like, as long as Ukraine does, because Ukraine, it was strategically, it was a real bad position
30
for
years
to be in. Yeah, so
for 30 years ago, we promised we're not going to extend NATO eastward, and since then we went to all the Baltic states, we went to Poland, and now we're threatened. We tried to go to Georgia, and if you look at it from a Russian perspective,
yes,
if you want to look at it from a Russian perspective, it's basically the exact same thing as Russia putting missiles in Cuba, is us putting
and
missiles.
Canada. No, actually in Mexico or Canada.
Right.
Yeah, that's what we're talking about.
We had a Cuban
Missile Crisis. Yeah.
So that's why I'm saying that. But you're right. It's the same thing as putting on the border of Canada, or the border and on the border of Mexico, and saying you should be totally fine with this. Why are you having a problem with this?
Yeah, come on. These are we're not going to do anything, even though we got all these missiles here.
We're all good. We're all good. Why do you have a problem with this?
Like hell no. Go ahead and get them out.
You out of freaking mind.
So I understand the Russian piece, but
Yeah. At the same time, he's a pretty dark character, and he's almost certainly killed his own political adversaries, and he's shut down anything that's any type of speech that's anti his government. He clamps it down. So he's not exactly a good guy, but his actions here are something that everyone should have expected.
Yeah, I don't think it was a surprise for anybody.
Yeah.
All righty. Well, on that note, I think that we have covered everything that we wanted to talk about. So unless there's anything else that you guys want to add to the conversation.
You said you were going to bring up the Biden pick thing. You said you were speaking.
Well, did you guys want to watch it? Did you or do you have to go?
I got 5-6 minutes left, so I don't know.
You're going to do this in 5-6 minutes? That's never going to happen.
Well, we'll see. We'll see. Well, I'm already. To be honest with you, I'm already dressed. I'm just got to leave the door. I've got to leave here about 2:30, but I'm gonna eat too. So, but I have a couple of minutes.
Okay. All right. Then let's do it then. I will share my screen. Okay, let's see here. And volume is on.
Family background have earned.
Do you guys hear it?
Yep.
Yep.
Good.
They went on to say they're confident she will, quote, approach her future cases with an open mind and treat issues related to law enforcement fairly and justly. Incredibly, Judge Jackson has already been confirmed by the United States Senate 3 times. First, to serve on the U.S. Sentencing Commission, a bipartisan independent commission I helped design to reduce the unwarranted disparities in sentencing, transparency, and fairness in the criminal justice.
Unwarranted because he wrote the bill to send them away forever.
He was known for working with Democrats and Republicans to find common ground on critical issues. Second, she was confirmed by the United States Senate with bipartisan support on the federal district court to administer justice with the special rigors and fairness that come with presiding over trials. Third, she was confirmed with bipartisan Senate vote to serve on the U.S. Court of Appeals for the District of Columbia, considered the second most powerful court behind the Supreme Court itself. And the court she once argued cases before as a distinguished
By whom?
When Judge Jackson was nominated to the Circuit Court, one of his distinguished retired members, Judge Thomas Griffin, a former general counsel of Brigham Young University and a George Bush appointee to the court, said he backed her enthusiastically, hailing her exemplary legal career in both public and private practice. And he went on to say her careful approach as a trial court judge. Judge Jackson's service on the District Circuit Court for the DC Circuit Court of Appeal is another superb qualification for service on the Supreme Court. 3 of the current Supreme Court justices also served as the DC Circuit judges, where Judge Jackson now serves. Her opinions are always carefully reasoned, tethered to precedent, and demonstrate respect for how the law impacts everyday people. It doesn't mean she puts her thumb on the scale of justice one way.
Of course she does.
But she understands the broader impact of her decisions.
Not just her thumb, she sits on it.
Addressing the rights of workers or government service, she cares about making sure that our democracy works for the American people. She listens. She looks people in the eye, lawyers, defendants, victims, and families. And she strives to ensure that everyone understands why she made a decision, what the law is, and what it means to them. She strives to be fair, to get it right, to do justice. That's something all of us should remember. And it's something I've thought about throughout this process. As a matter of fact, I thought about it walking over here with her. 1 floor below, we have several displays celebrating Black History Month. One of them includes the judicial oath of office taken and signed by Justice Thurgood Marshall himself, an oath that will be once again administered to a distinguished American who will help write the next
chapter. Is he the only one who took that oath?
The journey of America. A journey
they give him a special
Jackson
oath?
I don't think so.
I
hope I don't embarrass him, but her husband, Patrick, a surgeon, doctor. Patrick, stand up. Let him see who you are.
You remember when he said that about the guy who was in a wheelchair? He was like, John, stand up. He's like, oh, what am I talking about, John? You're in a wheelchair. Did you see that one? You didn't see that?
No.
Oh, it's a crazy clip. He told the guy in a wheelchair to stand up.
He should have put his hand on him. Stand.
She had her second child, Layla, when she served as on the U.S.
Power of Christ compels you.
I asked Layla and I showed her through the office whether she would like to be president. She looked.
Oh man.
There's other things. Anyway, Leila, you're welcome to be here. Thank you so much. And welcome your sister who's up in school in Rhode Island now. I have children and grandchildren. Let me tell you, Judge, you're always a mom. That's not going to change no matter what you're doing, whether you're on the Supreme Court or not. And I've always had a deep respect for the Supreme Court and judiciary as a co-equal branch of the government. I mean it.
That's why I want to expand it.
As important as the presidency or the Congress. It's co-equal. So today, I'm pleased to nominate Judge Jackson, who will bring extraordinary qualifications, deep experience and intellect, and a rigorous judicial record to the court. Judge Jackson deserves to be confirmed as the next Justice of the Supreme Court. I've met with the chairman and ranking members of the Senate Judiciary Committee, Senator Dick Durbin, Senator Chuck Grassley, and my hope is that they will move promptly, and I know they'll move fairly. Judge Jackson, congratulations, and the podium is yours. Let me pull this out.
So as of this minute, are there 8 members of the Supreme Court and Breyer's gone, or is he?
No, he's just waiting for the next term. So he's leaving after next term.
After the next term.
I mean, after this, when the start of the next term.
Mm-hmm.
Andy the Game Maker says he didn't realize the guy was in a wheelchair, but was quick to tell everyone to stand for him immediately after.
Thank you very
Politician's
much,
gonna politician.
President, I am truly humbled by the extraordinary honor of this nomination, and I am especially grateful for the care that you have taken in discharging your constitutional duty in service of our democracy with all that is going on in the world today. I also offer my sincerest thanks to you as well, Madam Vice President, for your invaluable role in this nomination process. I must begin these very brief remarks by thanking God for delivering me to this point in my professional journey. My life has been blessed beyond measure, and I do know that one can only come this far by faith. Among my many blessings, and indeed the very first, is the fact that I was born in this great country. The United States of America is the greatest beacon of hope and democracy the world has ever known. I was also blessed from my
Biden
early
says
days
part of your blessing is you were born a black woman.
and loving family. My mother and father, who have been married for 54 years, are at their home in Florida right now, and I know that they could not be more proud. It was my father who started me on this path when I was a child, as the president mentioned. My father made the fateful decision to transition from his job as a public high school history teacher and go to law school. Some of my earliest memories are of him sitting at the kitchen table, reading his law books. I watched him study, and he became my first professional role model. My mother, who was also a public high school teacher, provided invaluable support in those early days, working full-time to enable my father's career transition while also guiding and inspiring 4-year-old me. My only sibling, my brother Kitaj, came along half a decade later, and I'm so proud of all that he's accomplished. After graduating from Howard University, he became a police officer and a detective on some of the toughest streets in the inner city of Baltimore. After that, he enlisted in the Army, serving 2 tours of duty in the Middle East. I believe that he was following the example set by my uncles who are in law enforcement. You may have read that I have one uncle who got caught up in the drug trade and received a life sentence. That is true.
Oh,
But
getting
law
ahead of bad
enforcement
facts.
also runs in my family. In addition to my brother, I had 2 uncles who served decades as police officers, one of whom became the police chief in my hometown of Miami, Florida. I am standing here today by the grace of God as testament to the love and support that I've received from my family. I have also been blessed with many dear friends, colleagues, mentors, law clerks, I could not possibly name all of the people to whom I owe great thanks. But I must mention specifically the 3 brilliant jurists for whom I had the privilege of serving as a law clerk at the outset of my legal career. U.S. District Judge Patty Saris in Massachusetts, U.S. Court of Appeals Judge Bruce Selya in Rhode Island, and last but certainly not least, Associate Justice Stephen Breyer of the Supreme Court of the United States.
Interesting.
Justice Breyer, in particular, not only gave me the greatest job that any young lawyer could ever hope to have, but he also exemplified every day in every way that a Supreme Court justice can perform at the highest level of skill and integrity while also being guided by civility, grace, pragmatism, and generosity of spirit. Justice Breyer, the members of the Senate will decide if I fill your seat, but please know that I could never fill your shoes. To my dear family, those who are here with me now and those who are watching from home, I am forever indebted to you for your love and support. To my beloved husband, Patrick, thank you for being my rock today and every day for these past 26 years. I love you. To my daughters, Talia and Layla, you are the light of my life. Please know that whatever title I may hold or whatever job I may have, I will still be your mom. That will never change. There are so many other people I would love to be able to address and to thank, but time is short, so let me end by sharing an interesting coincidence that has actually meant a great deal to me over the years. As it happens, I share a birthday with the first Black woman ever to be appointed as a federal judge, the Honorable Constance Baker Motley. We were born exactly 49 years to the day apart. Today, I proudly stand on Judge Motley's shoulders, sharing not only her birthday, but also her steadfast and courageous commitment to equal justice under law. Judge Motley's life and career has been a true inspiration to me as I have pursued this professional path. And if I'm fortunate enough to be confirmed as the next Associate Justice of the Supreme Court of the United States, I can only hope that my life and career, my love of this country and the Constitution, and my commitment to upholding the rule of law and the sacred principles upon which this great nation was founded will inspire future generations of Americans. Thank you again, Mr. President, for this extraordinary honor.
All right. So she seems like a nice person.
Forgot to introduce.
They all do.
Joe Biden.
Yeah.
And the second gentleman, that seems strange to say that, but second Doug is Emhoff. They're both here as well. So thank you. Thank you all.
He had to mention the wife and the second gentleman.
She's like, you got to talk about me.
Second gentleman.
Anyhow, but that's okay. Cool. Interesting. So yeah, so she, I mean, as far as her record, I want to definitely look into her opinions and things that she's written in the past, to see how she's ruled on things and where she might stand on different things. But I definitely want to be paying close attention to the Senate, the confirmation process, exactly, the Senate hearings and whatnot. So
yeah, that should be fun.
Yeah, that'll be super, super interesting. And I would love to live stream those if possible. So anyhow, but yeah, what are your guys' thoughts?
I don't know her well enough to weigh in on her judicial insights. So
yeah, I just assume she's qualified because she's been confirmed all these other times. I think that'll probably be the big thing now because if you've just been confirmed to all these other seats, getting to the next seat, it's going to be more contentious. But I'm assuming she's going to be confirmed.
Yeah,
here's the Biden gaffe too. I shared the video for the Biden stand-up gaffe.
Okay, yeah. Let's do it.
And I also am told that Chuck Graham, state senator, is here. Chuck, stand up. Chuck, let him see you. Oh, God love you. What am I talking about? I tell you what, you're making everybody else stand up, though, pal. Thank you very, very much. I tell you what, stand up for Chuck.
I mean,
let's all mock him that he can't stand. So all the rest of us.
You can tell I'm new.
You can tell I'm new.
Let's pick you up out of your chair.
Oh, man.
So everyone can see you.
Funny thing is, he had been a politician for a long period of time before that point. Like that was not like in the last few years. Like
that's when he was vice president. Yeah.
You can tell that he was much more limber back then, as opposed to like the way that he kind of lumbers in and out of the room now,
being led by a man.
Yeah, but he's been in the Senate for. I mean, he was in the Senate for decades, I think, before he was vice president. So so for him to say you can tell I'm new, that's interesting. But anyhow, but I will say, as far as gaffes go, I think he recovered kind of quickly from that to be like, oh, what am I saying? And like, oh, everybody stand for you. Like we're paying you respect.
That's how you're the politician, baby.
Yeah.
Politics.
True. One last super chat.
I gotta go,
Iron
guys.
Bob says SCOTUS is co-equal branch. SCOTUS has checks on it. I think that was in response to Biden. So anyhow, but yeah, let's we'll wrap this up now. We've definitely gone on much longer than I thought we would on this, but this was great. Thank you so much for joining. Thank you to Good Logic. Thank you to Nate the lawyer, and thanks of course to Uncivil Law who dipped out a minute ago, more than a minute ago. And I will see you guys in